everyone. A very good morning and welcome to 13th World Litigation Forum 2023 Dubai, scheduled on January 17 and 18 at Pullman, Dubai Creek Center. Today, that is on January 17, 2023, we mark the 13th milestone of World Litigation Forum at Dubai. I would like to take this opportunity, myself Shruti Singh, Vice President, Business Development for World Litigation Forum. I'd like to take this opportunity to thank you all for coming and connecting this morning. Also, our esteemed speakers for taking part in this event. The quality and caliber of speaker this year is outstanding. I would also like to extend gratitude to our sponsors, Rakesh, BSA Ahmed, FTI Consulting, Lighthouse, Menteso, and Solid Legal Marketing. In today's conference, we will cover some of the most interesting and trending topics of litigation industry in 2023, starting from future of class actions, adoption of AI, ML, and blockchain in litigation, the importance of independence for effective expert evidence, force major claims, anti-money laundering, and enforcement issue in commercial litigation. Other than this, in 2 days, we will witness some interesting networking sessions and a lot more. With this, I would like to start our first session of the day, which is Future of Class Actions. The moderator for session is Sabina Noreen Malik, who is a consultant solicitor, Alexander James Solicitor UK. Our esteemed panelists are Pastor Daria, who is a partner in Legends Italy. We have Robert Whitehead, who is a partner, Hamdan Al-Shamshi, Dubai. We have Mohammad Al-Ghatid, managing partner, OGH Legal, Dubai. And then we have Alice Flacco, who is a general counsel, Microport, Scientific Corporation, France. So with this, I would like to welcome our speakers, our attendees, and our sponsors. May I have a huge round of applause for all of us. So thank you, everyone. With this, I'll hand it over to Sabina Noreen Malik to start with the session 1 of the day. Sabina?
Thank you so much for being here. It's my second time in Dubai. I'm Italian. I work in France. Come from Rome, the most beautiful, well, one of the most beautiful cities in the world. I'm general counsel for a healthcare company that holds its headquarters in. Our main mother company is Chinese, and we're going through now a series of debates and regarding the first recession that is coming from China on the aftermath of COVID. We are dealing with a class action right now, actually, in Italy for a clawback that is demanded by the government. And maybe if I have the time after with the questions, I will share how this class action is powerful to basically overrun and overrule the letter of the law, actually, not only as a private action, but also as a public initiative. So class actions, as my esteemed colleague said, is the subject of our analysis today. I would like to give you a perspective of European law, more focused on France, and then we'll have a generic overview of also how I see it in the in the Emirates. So the analysis can be divided into 2 parts, what I propose you. The first will present the action. The second will focus on the procedure. It's more of a critics and reflections, because I think that you're all very accustomed to this kind of action. So the action from a new law that has been enacted in France, which is inscribed in the Consumer Code, can be presented through 2 sets of data, subjective data and objective data. First of all, the subjective data. It's a question here of defining the parties to the action. Let's start with the plaintiff, then the defendant. The plaintiff. The group action is a registered action. The law gives standing only to nationally representative and accredited Customer Protection Association. So not, you really have to respect that requirement to be able to enter into a class action. For a long time now, consumer associations have had the right to act in the defense of the collective interest of the consumers. Here, the purpose is quite new because the association is invested with the right to act for the defense of the individual interest of a plurality of consumers. For the association, it is a matter of obtaining compensation for individual prejudices suffered by consumers placed in a similar or identical situation. This is why it's a class action. It's basically the same interests that are damaged. For the new leitmotif in French law, let's plead by prosecutor, but a politically acceptable prosecutor, a good consumer association, and only a good one, right? So this will avoid the liberal self-interest errors of other systems that enshrine group action. One thinks, of course, of the American president. And if generously, another article of the new reform provides for the possibility for the association to appoint any person belonging to a regulated judicial profession to assist it, this can only be done with the authorization of the judge. So you can see that already how you propose the action is quite regimented. The defendant now. It is not clearly defined in the law. It is only stated in one isolated article that the association can act to obtain compensation for damages having as a common cause as a failure by one or the same professionals to meet their legal or contractual obligations. Professionals are only referred to in the determination of the irreparable harm, but not in relation to the status of the defendant in the action. No matter what, we will say, whatever, but it is obvious that the defendant in the action will be the professional or these same professionals who failed to fulfill their legal or contractual obligation. Perhaps, but if we touch a word on insurances, which are like super dramatically important in Europe, could the Consumers Association thus summon the liability insurer of the professional invoking the benefit of the direct action? Question mark. So after the subjective data, let's talk about the objective data characterizing the action. These objective data are all related to the determination of the damage that can be repaired through the group action. This repairable damage is defined by its character. It is an individual damage suffered by several consumers, its nature, and its cause. Its nature. The group action can only concern the reparation of patrimonial economical prejudices resulting from material damages suffered by consumers. Here is a nugget nestled in the hollow of a mediocre text. Here the legislator takes side in one of the most refined doctrinal debates in the law of liability and clearly distinguishes between damage and injury. Its cause, in the sense of efficient cause, the law multiplies here the conditions of reparation. The individual injuries must have been suffered by consumers placed in a similar or identical situation. They must have a common cause in the sense of an efficient cause, and this common cause is legally defined. It resides in a breach by the professional of his legal or contractual obligations. Again, this failure must be established at the time of the sale of goods or the provision of services, and or when these prejudices result from anti-competitive practices. That's the broad outline of the action. So in the terms of procedure, this is, again, given to the characterization and the judgment of the first instance court, and then it's organized around the judgment, and there are its consequences. Then, as regards the judgment, the new law defines two outcomes. There is a common law procedure, and there is also a simplified procedure. I'm now going speedy because my sweet moderator told me that I only have 2 minutes. So just a criticism, the review. As first, a quick look at the new provisions may lead to a positive judgment. It is not indeed satisfying to see the legislator concerned with the protection of a party deemed to be weak in the contractual relationship, favoring procedure for the compensation of the prejudices. So this is a perverse effect. Criticism can be leveled at 2 stages. First, at the stage of the very principle of the group action. Second, at the stage of its implementation in the new system, which is very jeopardizing the whole balance right now in France given to the new law. So, of course, we should not be too critical. Certain essential choices made by the legislator could be considered as least bad. One thing, for example, of the choice of the opt-in technique, which is also a possibility. The members of the group must express their wish to be aggregated in the image of the Canada precedent rather than the opt-out technique, which would have upset the French procedural principles in a much more serious manner. On a glimpse on the group litigation, as personally I have experienced it, or through my French lens in the Emirates. The United Arab Emirates has a relatively young legal system. And of course, you guys can teach me about this, and the potential is really interesting here. It's a relatively young legal system and has only recently begun to see the development of class action lawsuits. However, as the country continues to grow and evolve, the need for an efficient and effective means of resolving disputes for a large group of people is becoming increasingly important. One potential avenue for the future of group litigation in the Emirates is the use of alternative forms of dispute resolution, such as mass arbitration or aggregate settlement. The UAE is already known for its strong arbitration system, and it's at a dedicated center for commercial arbitration. This could be expanded to include mass arbitration, where a large group of people can resolve disputes with a single arbitration proceeding rather than individual lawsuits. Another trend that could shape the future of group litigation, as we see it from Europe in the United Arab Emirates, is the increased use of technology, because this is for sure a potential for growth which is immense here. Electronic discovery and the use of big data and machine learning could make it easier to collect and analyze evidence in class action lawsuits, increasing their efficiency and effectiveness. Last point, additionally, as the UAE continues to establish itself as a hub for international business and trade, there might be a growing need for a class action lawsuit to address cross-border disputes. This could lead to the development of more specialized laws and procedures to handle these types of cases and the establishment of a legal framework for class action right here. Overall, with the United Arab Emirates legal system, while this legal system is still in the early stages of developing class action lawsuits, there is a potential for the country to adopt alternative forms of group litigation and use technology to improve the efficiency and effectiveness of these lawsuits in the future. Thank you so much. I think I've run over time, and I'll lead to my...
Just to expand on that, to bring a class action, you've got to have a commonality. So we'll bring you to the case of Google versus Lloyd, in which 5.4 million people were affected, and a class action was brought together with that large group in one claim, which is quite amazing. But the problem we had is that it was a potential loss of control, which is different to damages, compensation for damages or distress. And so for that reason, the courts discouraged a large class action because the breach of data didn't actually impact each claimant enough. And so usually what they will have in place is a test case. The test case will be progressed and then the group will be formed. And the way it's formed is they will invite people in an opt-in situation to say, come and opt into this, they'll advertise, and each fact has to be similar in the case. The value of the quantum doesn't need to be. And in line with that, they usually have funders in place. So third-party funding would come in, third-party funders, and that would include conditional fee agreements, AT insurance, but we can touch upon that later as the session goes on. And from my perspective, again, this is just a discussion, and the disclaimer is that we are not giving legal advice on the panel, it's just a discussion. It's possibly data protection claims may go towards competition law, and it could be that the claims have been sold for an unfair value, and so for that reason, the claimants may be given the option to opt out, which is the American way forward, which is now slowly coming into Europe and the UK, and the courts are becoming more in line with what's going on in America, and that gives what happens in an opt-in is the claim is advertised, you opt in, but if it's an opt-out, anybody in that pool is automatically placed in, and they have the option to then opt out themselves and say, I don't want to be part of it. But with that said, I'll pass you on to my colleague Daria, and she'll continue. Thanks for listening.
Hello everybody, I'm Daria Pastore. I'm a partner of Legans law firm, it's an Italian law firm. I'm based in Rome, and I confirm that it's one of the most beautiful cities in the world. So hope that you can come, and so we can have a coffee close to the Colosseum. And so I'm also an officer of the International Bar Association Class Action Committee. And an officer of the international section of the Rome Bar Association. Class action is a very interesting and hot topic now in Italy because a reform has entered into force in May 2021, so very, very recently. And it was very interesting to listen to Alice because the previous system in Italy was mainly very similar to the French system. At the same time, there are both civil law systems, but there is now, today, a huge difference between these two systems because in Italy, this reform, the goal of the reform was to facilitate the use and to expand the application of the class action in Italy, not only limited to consumers, but also to everybody, to any individuals that have similar or identical situation, individual rights. So that's why there is a huge interest, in the class action now in Italy. So the scope of application is not limited only to consumer claims and to consumers. In the major change is this one, because of course until this reform, we noticed that there were not so many class action, and there was a great problem, about the admissibility of this class action. So the reform tried to overcome this kind of problem. So the class action procedure is now available for both B2C and B2B claims and relationships. It's not limited to contractual relationship, but also to tort. So you don't need to have a contract to start a class action. From a procedural perspective, the choice was for a very fast procedure, which is a summary procedure provided by Italian Civil Procedure Code. And there is, a first phase, which is an admissibility phase, and it's the more delicate phase of this proceeding. This admissibility phase, at this stage, this begins with the publication of the petition filed by the plaintiff on a specific online platform set forth by the Ministry of Justice. So in this way, everybody could, I don't know, okay, sorry. In this way, everybody could know about, the existence of this class action. This is why, because in Italy we have an opt-in system. It was before the reform, and it remains this system. So completely different from the American system that, as Sabina was saying, is an opt-out system. And it will not change because it's not, it's against the principle of the Italian constitution to have an opt-out system. So I don't think that it will change in the future, at least for now. So the publication allowed to people that want to individual with homogeneous rights and homogeneous claim to join the class action soon after the publication. Afterwards, within 30 days, the court will decide on the admissibility of the class action. And so we'll accept the class action, we'll recognize the possibility to continue with the class action unless any of these events occur. If there is a clear lack of merits, if the claims are not homogeneous, the individual rights, if there is an existence of a conflict of interest between the plaintiffs and the defendant, or if, for example, the plaintiff is not adequate to protect the collective interest. This first phase is very delicate, and actually Italian courts were pretty reluctant to admit now the class action, mainly because it was very difficult, to demonstrate the situation, the similar situation, the identical situation, but I think that it will change. I mean, there is a great interest in the class action, as stated. After this admissibility moment, if this is recognized, so it admitted the class action, then there will be like a gathering phase, which gives to the judge broad powers. In Italy, we do not have disclosure. So, I mean, it's uncommon to, it's not usual that the judge order to obtain documents from the party. We have some form of disclosure, which is the order of exhibition, which is requested by one of the parties to the judge, even if this document is not possible to be obtained in another way. And the judge has a discretion to admit or not. The problem is that there is no real sanction if you do not comply with the order of exhibition of the court. So we don't have a proper disclosure system. However, in the class action, it was introduced in a broader power of the judge to obtain these documents by the party. So this is everything to facilitate the class action, of course. Then there is a final stage, which is not a final stage where the judge order, the payment of damages, the compensation of damages, etc., but just ascertain the liability of the defendant. Just say if there is liability or not. And this moment, there is a second moment to opt-in. After, this second moment, is it possible to opt-in for individuals? So we have two moments to opt-in. At the beginning of the class action with the publication, or soon after the publication of the class action in the Ministry of Justice website, and then a second moment, which is this one. So this is mainly the procedure. Then a second phase will follow for the liquidation of damages. And this is mainly handled by the lead counsel. Since I have not many minutes left, so I would like to, so this is mainly the procedure. We will see what happens, of course, there are some points, still to be discussed in the courts, and so there is not, significant case law still in the case. So we will see how, maybe we'll see each other in 2-3 years, and we will see how this works really in the reality. In my experience, and I think that the main areas where this class action could be really interesting would be, for example, the ESG litigation or the climate change litigation, because it's this idea of homogeneous. I'm okay with the time? Okay. This idea of homogeneous, rights fits very well, in my opinion, with climate change and ESG litigation. So I see these trends, for example. So disclosure-based claims, so claims generally brought by investors and shareholders that include allegation for failure to disclose climate change-related risk, for example, creating a stock drop scenarios where share prices fall for climate risk-related reasons, for example. So that's, for example, in this context, it's relevant to consider the ESG reporting obligation. Greenwashing claims. We are seeing in Italy there are a lot, of greenwashing claims before the antitrust authorities. Of course, this kind of claims could become a class action also before civil courts. And for greenwashing, I mean all the action linked to the misleading green advertising claim, such as carbon neutrality, offsetting of emissions, and anti-competitive conduct. Such claims could potentially be brought by investors and shareholders also, who were persuaded to buy or invest in the green financial or non-financial products by the misleading information provided at the business market, plus by the consumer that bought certain products thinking that it was, green. And the other is the violation of directors' duties-related claim. Claims brought by shareholders and stakeholders due to directors' alleged failure to have accurately considered the impact of climate change on a company's operation or to have adopted adequate emission reduction strategies, all determine climate-damaging investment decisions causing investment losses. Of course, there are also other areas of climate change, but I see after studying this also with the IBA, we noticed that these three areas could be the future trend for class action. Thank you.
Thanks, Daria. That's most important, the climate change. And of course, governments want net zero by 2023. And so the policies and the legislations are coming together, and there's huge pressure to urgently address these climate change issues. And I'm sure there will be plenty of cases coming forward, and there will be group actions and class actions starting with regards to these emissions that are currently going against the changes that are necessary at the moment. With that said, thank you. We'll pass this on now to my colleague and the next on the panel, and then let you introduce yourself and give a perspective of working. I know you've worked UK and Dubai, so it would be nice for the audience to hear a perspective of what your experience has been like on both sides. Thank you.
Of course. Thank you. Yeah. So, hi. Good morning, everyone. Thanks for coming out today. My name's Robert. I'm partner and head of DOC at the Hamdan Al-Shamsi Lawyers and Legal Consultants. We at the firm, we basically have sort of three divisions. We've got a corporate division, we've got a Dubai court division, and we've got a DIFC court division. So for those who are not aware of what the DIFC court is, I'll just give a very brief overview, and then I'll dovetail that into how it might apply to class action cases. So the DIFC courts essentially was set up to deal with international investors, mainly because they wanted, or it was seen that they wanted a more familiar environment, a legal environment for them to carry out legal disputes in. So unlike the Dubai court federal system, the Sharia law system, it's our common law system, and it's very much based on the UK law system and the common law UK system. So it's very useful, and obviously me being a UK lawyer, it makes sense for obviously practicing in that area. So it is what the purpose of explaining that is that the DIFC courts in Dubai, there is definitely scope and potential for class actions. At the moment, from my experience, and obviously I know a lot of practitioners who work in DIFC, it's not that prevalent in Dubai or in the UAE at the moment. Having said that, as my panelists have discussed, I think there is a lot of potential for it to become more prevalent and commonplace. So I think just before sort of going into how that could be the case, I just would like to highlight some of the key features why class actions are important. Obviously, as my panelists have said, it's group litigation. It's where multiple claimants with claims sharing common characteristics seek a remedy against the same defendant or multiple defendants. So again, in the English system, it's been prevalent for over a century. There's been several significant cases. We've probably all seen a lot of the Hollywood movies, Erin Brockovich, all these ones, American US litigation. So we're all sort of familiar with what it is, mainly tortious claims. But the main types of claims are obviously tax disputes, product liability claims, environmental claims, as we've discussed, data breaches, gross negligence, and shareholder claims. So I think in terms of for the DIFC, again, there's not, as far as I'm aware, there's not been a massive claim as yet, but I think that there may be in the future. And I think the key point here is that obviously in the English system, there has been some huge claims, which I just want to touch on now, and then we can see how they sort of cross to potentially Dubai. So I think the biggest claim, which is worth talking about in terms of a data law class action, is the Lloyd versus Google case. Is anybody aware of that case? Has anybody sort of been involved in that case? No, that's fine. All right, I'll go through it then. Essentially, what happened here was, as my colleagues mentioned, it was on an opt-out basis, and it essentially was a case which involved the Data Protection Act 1998. So in the DIFC, there's just been recently a Data Protection Act introduced in the last 2 years or so. There has been one in the UAE. Federal law introduced it at the back end of last year. So all these things, it is a very embryonic stage still, the UAE, in terms of the legal system. But the Data Protection Act and the GDPR, there's a lot of correlation. So basically, in Lloyd versus Google, what happened was a chap called Richard Lloyd, he brought a representative action on behalf of over 4 million data subjects. And here he sought damages for an alleged breach of data protection law. And essentially his claim was that the Safari workaround on iPhones, basically that because there was a Safari workaround on iPhones, Google was able to track user data without their knowledge or consent and create user profiles for targeted advertising. So we've all seen now, when you go on any website, you're always asked to, do you reject or accept the cookies? You know, we're all aware of that. So this litigation is off the back of that. It's a very important piece of litigation. Essentially, Mr. Lloyd, he sought a uniform amount of £750 in damages for each class member. But because there were so many class members, that made £3 billion in total. So it's a huge claim. Google was successful in the High Court in the case. However, the decision was overturned in the Court of Appeal. When it was appealed, it was decided there were two principal issues which the parties had to decide on. The first one was whether damages could be recovered under the Data Protection Act for loss of control of personal data, even if no material damage had been proven, and whether each class had the same interest in the claim. So it's essentially like any tort claim, you've got to prove damage. What happened here was it was decided that damages could not be awarded purely for loss of control of personal data.
Sorry, you have a question at the back.
Sorry, yeah.
Is there a question at the back? So you put your hand up. Sorry.
Yeah, fine. All right, so that's the implications of Lloyd. I think in terms of, because I'm conscious we've only got a limited amount of time, the other really big case that I'd like to discuss, and excuse my pronunciation, I'm sure my colleagues will be able to pronounce it better, but it's this Municipal de Marina and others versus BHP Group case. So this is a huge case because it was proceedings brought against BHP Group and BHP Limited, which were both English and Australian companies. And this was in respect of the dam failure which happened, which was massive case. I'm sure a lot of you are aware of it. The dam was owned and operated by a Brazilian incorporated joint venture, and the amount claimed was £5 billion, and it was brought by over 200,000 claimants. So this made it one of the largest claims in English legal history. The court struck out the claim as an abuse of process because there were concurrent proceedings concerning the same matters in Brazil. So again, that could be the same in Dubai. For example, if you had a claim in the English courts and in the Dubai courts or the DIFC courts, then you could have a situation where there's parallel proceedings. Basically, what happened here was that the court then reopened the decision and allowed the claimants permission to appeal on the condition that they paid the full amount of the costs. And the permission was granted, and the court considered that the first instance judge had failed to address some of the essential points at the heart of the claimant's challenge, which basically undermined the integrity of granting the appeal. So again, as my colleagues have mentioned, this greenwashing and climate change litigation, I think that is going to be a huge area for the future of class actions, and I think we will see more class actions in the DIFC courts in years to come. And with that, I'll pass over to my colleague.
Thank you so much for that. Absolutely well addressed. And yes, you know, there are multiple causes of action, as rightly said, and you know, the confidence that needs to be brought into the market, into the UAE to progress these claims is much needed. And the claims are not potentially funded by the claimant themselves. There will always more than likely be a third-party funder that comes in and will take a percentage at the end of the case, and then usually counsel and the solicitors will also work on a conditional fee agreement whereby the class action can proceed without the need of funds being put in place immediately. It's a third-party funder that would do that on the behalf and then take a percentage at the end. But that can be addressed later in the break if anybody wants to touch base, because we are conscious of time and we still have Mohammed to give us his insightful opinions on and views on this topic. So with that said, I'll pass it over to Mohammed.
Thank you. بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين. I know that I'm speaking on behalf of most of us when I say sitting down is what we do all day. So on the opportunity of standing up, I never let that go by. I'm not from Rome, but I'm from a country that I would think comfortably competes with Italy. I'm Egyptian. I'm the founding partner of OGH Legal. If we were to have to meet in Rome, I would prefer the Trevi Fountain, not the Colosseum. Yeah, it's not bad. Even if you had not heard from the panel this morning, I think it's obvious knowledge that UAE is a very legally infant jurisdiction. In some respects, people will look at that as a disadvantage, but I think in reality, it's quite exciting to see a legal regime actually evolve as you're practicing law, as opposed to refer to historical development of law. You actually see it occurring. Many of us who are practicing in the UAE will tell you, well, when I started practicing, this was the position of the courts, but now this is the position of the court. So it's quite fascinating, to say the least, to see that technically infant jurisdiction evolve. Add to that is a very unique ingredient in the UAE, which is that the government, the decision makers, are very agile. The jurisdiction is agile. The ability to adjust, to keep up with progress, I would say even compete with international jurisdictions, is, I think, undisputable. And I think that goes also with the idea of class action, with the idea of sustainable development, greenwashing issues. But I think before we delve into what the UAE's answer to class action is, which will be very short, I will confess, I think it might be useful just to go back to the basics. What are the advantages of class actions? You've heard my panelists touch on a few, and I think there are only a few. Issues of costs, the burden of pursuing a claim, the burden of pursuing a mammoth defendant with resources, not only funds, but general resources, and then possibly, depending on the jurisdiction, a lower burden of proof per individual defendant. So I don't have a fantastically good case, but my co-defendant does. If we group ourselves into one claim, maybe I will benefit from his better case. But if you pick those advantages apart, one could argue that a civil law system like the UAE inherently has ingredients that satisfy these advantages without having technically a class action. Now we look at the financial burden. Now in any, not in any, but in most jurisdictions that we heard this morning, there is a significant amount of financial burden on defendants when they come up against Google or other huge litigants or defendants. That being the cost of bringing a claim, but also the exposure of losing a claim, which is quite significant, particularly in the UK or other jurisdictions where there are cost implications. If you lose, you pay for the other side's costs. And if you obviously cannot, then you have to put up security or whatever cost guarantee for the other side to be able to recover your costs, to their costs. So this exposure, as it were, does not exist in the UAE. You can bring a claim. The cost of bringing a claim itself is, I would say, relatively low. And then the potential cost exposure is nil. I'm sure many of us who have seen judgments in the UAE, you will see that the cost implications at most will be a few $1,000s, if that even. I'm actually very liberal in what I said, probably only $1,000, a single $1,000. So that aspect of the cost burden, I would argue, is non-existent. Now the other is the burden of proof. Now one could argue that there are two limbs of that. One is the limb of the evidentiary value of documents, when you compare it with witness evidence, expert evidence, etc., which a litigant in other jurisdictions would need to occur. So you would need a very highly qualified expert. You would need a lot of expert witnesses. You would need a lot of factual witnesses. These cost money. There are cost implications with all of that. And it's ultimately a burden. If the other side has 10 experts on a very specific issue of technology or data protection, you'll have to match that. Otherwise, it's hopeless to bring a claim. Now, in local jurisdictions, at least in the UAE, that is not the case. That's not how cases are run. So one could argue, well, even if I go against Google, Google ultimately cannot flex its muscle that much because there are limits to the jurisdiction and to the expectation of a litigant in the UAE. I can have the best technical expert, but ultimately the person who will be reviewing this is the local court expert who, with all due respect, will not have the capability to know the difference between a high level and a mediocre level expert. So I would say that inherently the process is not that burdensome. Now I think the last issue is the question of, for lack of a better expression, the demeanor, the motivation to make a claim. There are instances where you have a case, but you would say, well, do I need the headache of pursuing one? And that's here where class actions could be a bit attractive. The other aspect is funding. We mentioned litigation funding. We mentioned the idea of contingency fees. Now, for the moment, neither of these are open in the UAE in any event. So if you were to enter an agreement with your local council on a contingency fee arrangement, and you would accept that, I can tell you a free piece of advice now: it's not enforceable. So the attractiveness or the idea of having a contingency fee is actually, again, non-existent. Now, litigation funding is a bit different, because the question is, what is the litigation funding arrangement to start with? And the question about characterizing that arrangement under local law is a bit, let me say, a virgin issue. So with that said, do I have 2 minutes? Or? So with that said, I'll just sort of gallop through a few, I think, new developments in the local court system, the local procedure, that I would say ties in with what I said in the beginning, the UAE being at the forefront of international competition in terms of the sophistication and utility of its local procedures. I mentioned that, or I didn't mention, but rather I do quite a bit of local court litigation, but I also do arbitrator work, where I sit as an arbitrator, and I do expert work, where I provide evidence on UAE, Egyptian, and Saudi law. And that sort of perspective gives me a very interesting ability to compare the various jurisdictions. And I will bluntly say that that agility with the local law is unmatched, I would say, even in jurisdictions like the US or England. Not necessarily because we're better, but simply we're agile. We're able to develop things much quicker. And you will be startled, if you don't know them already, by the changes that have happened over the course of the past 6 months, let alone the past few years. So in the past 6 months, you've seen the statute of limitations in bringing a court litigation decreased by half. So they've been halved. Now, one could argue that is quite aggressive, but one could also argue that that's commercially progressive. You're telling a claimant, if you have a claim, you have a shorter limitation period to act seriously about it, otherwise forget about it. The other point is the use of technology. I remember during the height of COVID, I had parallel proceedings in Germany where their issues were there that we were not facing in the UAE, at least in Dubai, where you had court sessions being done online overnight, literally. We were using Microsoft Teams on the court cases before we used them with meeting our international clients for private meetings. The use of technology, as I said, a big issue. Speedy decisions. Now, again, the very recent changes of the laws, in effect, half the period for appeals, force judges to make decisions on urgent matters within a very short period, force judges to limit the number of hearings per case, which is fantastic, I would say. The proliferation of enforcement treaties. We've seen ones with India, the EU, again, to promote commerciality of the judgments. You can have a very expensive judgment, but the question is, will you enforce it or not? I'm being told to wrap up. I think what I will leave you with is class actions are undoubtedly a very exciting, always an exciting prospect. One questions whether they're always suitable. I would say that the jurisdiction locally, be it the private courts, the IFC or ADGM on the other side of the road, being the right forum, the local courts being the right forum. The short point is it's an exciting time to be in the UAE. It's an exciting time to be litigating and involved in disputes in the UAE. So there's more to come, and good luck with the rest of the day. I heard the topics of the sessions, and I'm sure they'll be equally, if not more, exciting. Thanks.
Thank you, Mohammed, for a deep dive as to the prospects of class actions in the UAE. Now, we'll see what happens in the future with regards to third-party funding and litigation. And as rightly said, we do have in Europe and the UK after the event insurance, which covers a claimant's costs in the event they lose. So you wouldn't be out of pocket in any way. Your after event insurance policy would be put in place and the policy would cover you. But again, that's a question and answer session we can have at another time. Coming back to class actions, my panel, international panel, have gave you a great insight into this topic. Please can you now put your hands up and ask questions and don't feel shy. Please stand up.
Thank you very much. Thank you. Thank you very much to the panel for a very interesting overview of class actions internationally. My question is for you, Sabina, and partially Daria too. You both touched upon the distinction between class actions from opt-in and opt-out groups. My question is, how is a group of potential claimants built for opt-out claims?
Do you want me to speak?
Opt-out is more for you.
Opt-out is the American way forward, and what happens is you're automatically put into that class. So hypothetically speaking, Mercedes had diesel emissions and a claim was bought. That was an opt-in, but if you take that into an opt-out, what would happen is everybody within that Mercedes class would be put into the class action, and then it would be for you to opt out of it. You'd have one representative who would then act on behalf of all the other claimants, and you have one test case that possibly first would go through, and it would give you an idea of which cases are weak, which are strong, and the weak cases might be thrown out, but sometimes it's a balancing act, and you don't want to make your pool so wide just to get the funding in place, and you don't want it too narrow either, so that it can be scrutinised by funders. It has to be fair, it has to be advertised fairly. You have to give a cut-off point to say within this deadline, you've got to bring your claims forward. And in an opt-in on the opposite side, it's when it's advertised and you come into the claim yourself. So potentially that group's being built up rather than a whole group that's already built and then you're opting out of it. It's the opposite, you're opting in. But I'll let Daria expand a little bit more on that.
Yes, I think that the question is very interesting, and and these difficulties, in defining what is the group, and in Italy, and mainly the fact that in Italy, the idea that you could, without acting, without deciding, to claim for your rights, you can obtain also, a judgment. Which is, binding, even if in a favorable way for you, is something that it's against our system. So that's why in Italy we have the opt-in system, because you should be free to decide whether or not to claim your rights, and so that is the main difference with the opt-out system. It's something that we could not really realize, the opt-out system.
That answers your question. As again, in an opt-out system, you'd have that one claimant that would represent the group, and in an opt-in, you have a head solicitor or a head firm, a few firms of solicitors that would head that on your behalf. So potentially those are the minor differences, but we can touch base later if you want to have a chat in the networking session as well. Any more questions?
Do we have more questions from the panelists, because the session will wrap up in 10 minutes, so this is the time. Please put on your questions, bring it on, and make it more interesting. So we have it here, one.
Hi, thank you. Stacey Miller from Cronin Miller Litigation on the Gold Coast in Australia. Thanks for having us. Thanks to the panel. Something, Mohammed, that you said about the cost regime here in the UAE, and apologies for those that practice here, this might be a really simple question. I don't know whether it was specific to class actions or if it's answered by the insurance issue as well, but is it a no-cost jurisdiction or a limited cost jurisdiction? You said that there's no exposure in terms of cost orders.
So thank you. I wouldn't say it's a no cost jurisdiction, because there are costs awarded, but they're usually the court costs. So what the party would incur, or the winning party would incur during the course of proceedings, be it court charges, services of the court, etc., these are automatically recoverable. What is zero recoverable is the legal costs, or your team's costs, so private costs of the party that are not involving any court charges or authority charges. These are not recoverable.
Wow. And is that specific to Dubai courts as well as DIFC, or just?
No, so DIFC is different.
So DFC is similar to Australia, so you can costs follow the event.
Yeah.
So
Because it's common law as well.
Exactly.
Yeah.
Yeah.
And actually, while I've got you, how does the judiciary look in the DIF courts? Is that a mix, or is it all UAE-based judges, or how does that
It's a
work?
good question. No, it's a real mix. You've got Singaporean judges, English judges, Australian judges. It's a really good mix, and there's a real plethora of, it's great because obviously everybody's coming from a different jurisdiction, different background, and they do complement each other, and you can see that in the decisions, in the appeal decisions as well. And it's obviously a bit of a mixing pot, and they do focus in terms of making decisions on the Australian judgments, the English judgments, even New Zealand judgments. So it's great because as a practitioner, it is such an interesting area, because obviously they will focus on the DIFC precedents to start with, the judgments, but then if those precedents don't have what you need essentially in terms of the decisions, then you'd go to other jurisdictions. But just to pick up in terms of there are in DIFC and ADGM that you can go for contingency fee arrangements. You can't go for damage-based agreements, so you can't recover money in terms of the amounts recovered at the end of the case, but you can get an uplift on your rates. So it's, again, very similar. They've just based it on common law jurisdictions. Yeah.
Any other questions?
So there is this gentleman asking one more question. We can take a couple of more questions. So yes, please, audience, bring in on your questions.
Hi, this is Mehul Shah from Intellect Legal. I have my law firm in Mumbai, India. My question to the panel is that you have an opt-in, opt-out system at the initial stage. But let's say after a verdict,
Hello everyone, and welcome back to 13th World Litigation Forum 2023 Dubai. I hope you all had interesting networking session and amazing refreshments by Pullman. So with this, I will be resuming with the session 2 of the day, which speaks about the importance of independence for effective expert evidence. And we have some amazing panelists here with us who would be deliberating on this topic. We have Alexandra Ziolkovska, who's the director in economic and financial consulting practice from FTI Consulting Dubai. Then we have Simi Sharma, who is Director Economic and Financial Consulting, FTI Consulting Dubai. Then we have Thomas Parkin, who is Associate Caden Gates, Dubai. Then we have Tala Fahom, who is Associate Freshfield Brocas, Deringer, Dubai. So with this, I would hand it over to our esteemed panelists. So panelists, over to you.
Thank you. So thank you for introducing us. My name's Alex Żurkowska, and I'm a director in FTA Consulting. I specialize in damages assessment, and today I'll be moderating the panel on the importance of independence for effective expert evidence. We've been briefly introduced, but I'll give a couple of more sentences about each of the panelists. I'll start to my right with my colleague Simi Sharma. Simi is a director in FTI Consulting in the Economic and Financial Consulting Department. She's based in Dubai. Simi is a chartered accountant and has 10 years of experience in the assessment of damages and business valuation. Then further to my right, we have Tala Fahom. Tala is an associate in International Arbitration Group and Global Project Disputes Practice in Freshfields, also based in Dubai. She has experience in arbitration, litigation, and investigations with particular focus on the Middle East. And finally, Tom Parkin. Tom is an associate in the International Arbitration and Dispute Resolution team at KL Gates, Dubai. He focuses on international arbitration and commercial litigation, both in the Middle East and internationally. And we'll start our discussion by focusing more on the effective use of expert evidence, and then we'll move to the independence issues further in our discussion. We're also hoping we'll have some time towards the end for questions from the room, so if you have any during the discussion, please save them for the end. All right, so starting with the effective use of expert evidence, the first question is for Tom. Tom, what do you think are the characteristics of a good expert?
Thanks, Alex. Can I just say first off, thank you very much to FTI for inviting us. It's a real pleasure to be here. On the characteristics of a good independent expert in litigation or arbitration, I would say the first one is teamwork and the ability to be collaborative. I mean, we're going to talk quite a lot in this session about the independence of experts, and it's true that experts have to be independent in a very specific and formal way with the legal and ethical considerations that go with that. But in practice, day to day, when you're running a case, the independent expert has to work as part of a wider team with the client, with counsel, the legal advisors, and so on. So it's absolutely essential, I think, to deliver a good work product for the expert to be someone who is flexible, who is collaborative and transparent, and who can work with deadlines and who is willing to listen to other people's views and comments. Communication skills are next, because a big part of, essentially the large part of the expert's job is basically to act as a kind of translator for very complex scientific and technical concepts, and to be able to present those, whether that's in oral testimony or in a written report, in a way that a court or tribunal with no expertise in the particular subject can understand. But if I had to say the single most important thing, I would say, is depth of expertise in the particular issues that are the subject of the dispute. It's, I suppose, quite obvious to say that you want the expert to be an expert. But I think it's a real game changer for the expert to have a real deep, genuine, and thorough knowledge of the subject matter. That's partly because the expert's knowledge and understanding can open up new avenues and arguments that the lawyers might not have considered. And also because it's the one thing that lawyers can't add to. So if, let's say, the expert produces a report that's not very polished, not particularly coherent, that's annoying, but lawyers can deal with that. We can do a lot of remedial work to make it make more sense. I think the deep expertise is the one thing that lawyers can't help with, and that's where we really rely on a good expert to add value.
Yeah, so you talked quite a lot about expertise as the main thing. And Simi, now a question for you. Do you think it's not only the expertise in the subject area that's important, but also previous testifying experience? How important do you think is that?
Thank you, Alex, for that question. And I think experience is quite relevant and important. There is knowledge and skill, the experience around knowledge and skill that you gain over time by working on different matters and different projects. But then testifying experience is something that is really valued. A lot of experts talk about it, lawyers talk about it. Having said that, I think sometimes testifying experience doesn't matter. You know, it is about if you have the knowledge and the skill, and there are certain situations such as the issues are not very complex, issues are not very complex, or sometimes young experts can prove to be a very meaningful alternative when the clients are price sensitive, or in fact there is there is the expense of hiring a very experienced expert doesn't justify the economical value of the claim. Last but not the least, there is no substitute for rigor. Sometimes an inexperienced expert who is very close to the case details, who've thought about the issues, who has to form an opinion, who's very close to the legal issues and has married the expert opinion with the legal case, is sometimes far more valuable than an experienced expert who's probably not close to the case details and would not be able to provide an effective oral testimony, because they can't, sometimes it seems more credible when you can demonstrate that the work you've done and you understand the work and there is a basis for each opinion that you've formed. Thank you.
Thanks for making a very compelling case for appointing more junior and newer experts. Tala, now moving on to you, sort of revolving around the same topic. What in your view are the key considerations while appointing an expert? And if you were to put it on the flip side and think about negatives for a second, what would be the one characteristic that you'd say would discourage you from appointing an expert?
So like you said, we touched on this a bit earlier, so some of the key things that you think about when appointing an expert and that are really important are, of course, their independence from the parties at the time you appoint them and subsequently, the relevant experience, to some extent testifying experience, but I agree with what Simi said, their ability to explain their opinions to the layman, and their ability to handle cross-examination, and that one is really, really important. You've seen people present very, very excellent reports and then kind of fall apart at a hearing when they're picked on. But in terms of what would discourage me or us from appointing an expert, it's actually, having given it some thought, I think it was actually a softer skill and potentially one that's a bit selfish from a lawyer's perspective, but lawyers manage a lot of people over the course of an arbitration or dispute. And so someone who is difficult and who is not collaborative and not responsive is probably, someone who we would try and avoid working with. You can be brilliant, but ultimately it's a machine that needs to work properly, and you need to have drafts in on time. You need to be available to discuss them. You need to be able to work with, often it's not just one expert, it's many experts who are working all together and incorporating findings into, cohesive reports. So I think it could really derail the course of a litigation or arbitration or any kind of dispute, really, if you have a difficult expert. And Simi mentioned something yesterday when we were discussing this, potentially also falls into the same kind of softer skills, but maybe someone who is not very mindful of budgetary constraints, because again, lawyers typically manage that relationship, and so it is very difficult to have to continue to go back to a client and say, oh, well, we've gone over again or something like that. So just someone who's mindful of who can take a holistic view of the technical work, but also the day-to-day running of a case.
Thank you. All right, so now we briefly established what you're looking for in an expert. So now let's move to the process of selecting one. So Tom, what is the usual process that you follow when you're picking an expert?
I would say the process depends. I would divide it into two basic scenarios. And that's where you're looking, first scenario is where you're looking for an expert in a relatively common discipline. And the second scenario is when you're looking for an expert in a more niche discipline. So firstly, if you want an expert in a relatively common discipline of the kind that often comes up in disputes, for example, if you want someone to do a damages valuation, or if you want a delay analysis expert in a construction dispute, there are lots of people, lots of firms out there who specialize in that type of work. So if I want someone to do a damages valuation, I already know who the firms are in the market that can do that kind of work. I probably have specific individuals at some of those firms in mind. So that is more straightforward because you effectively already have a kind of short list of candidates. There's some work involved as well, but you start with a short list of candidates. And then you would go to those candidates, you would obviously clear conflicts, you would invite proposals. Usually you would ask for some kind of very high-level input, some kind of high-level response to the basic facts of the case to get a sense of the experts' views and how they would approach the issue to help to determine their suitability and their capabilities. But then really it's a commercial pitch, essentially. You want to find, you have 4, 5, 6 experts who can do the job, you know and trust them. And you want to find who is the best person who has the right sort of characteristics and expertise for that particular mandate. And of course, there's a fee element as well. That will be particularly important to clients. The second scenario is where you're looking for a more niche discipline, and that could be absolutely anything. And that's more complicated because generally you won't have any idea of who the candidates might be. You don't know necessarily even what kind of person you're looking for. It might be an industry expert, it might be an academic, a consultant. So there's kind of a research task at the very beginning to find out what kind of people and what candidates you might want to engage. And so that might involve talking to expert brokers, talking to the client might have contacts in the industry, professional bodies, industry experts, to try to figure out a list of who the expert could be. And from then on, the process, I suppose, is essentially similar. You would go to all of them, clear conflicts, get a proposal, and then assess who's the most suitable candidate. But there's probably an extra level of scrutiny there because some of the types of people that you're looking at, say academics are probably the best example, probably have no experience with the art of being an expert witness. So there's an extra level of scrutiny in making sure that they understand the expectations and that they're capable of delivering the whole work stream.
Thank you. Tala, is it similar from your perspective, or do you have different experience?
No, I think it's exactly the same. We've had some disputes where we just know who we want, and subject to there not being any conflicts, whether with the expert themselves or even internally, we'll discuss later. But you should be mindful of how often you engage a particular expert. There's been some instances where a partner will say to me, "Yeah, just see if this person's available." And we've had instances where we're looking at something that is so niche, where we'd have to take so many steps, like Tom said, where there's a huge amount of due diligence that goes into it. And that goes down, you prepare an entire presentation setting out who the expert is, what they've done. You have kickoff calls, you then have calls with the client of the shortlisted candidates. It's really a much more rigorous process and a very important one, obviously. And I think the one thing that we would typically do as well with a more unknown expert is to also check around the network and see if anyone's had any experience with them and if they could give feedback. So that's something that we often do for both experts and tribunal members because, you have institutional knowledge and you should use it.
So you mentioned looking for an expert who has the right expertise, unsurprisingly. But while selecting an expert, do you tend to think whether their opinions and views would match your client's case?
No, not really. Honestly, not really. Ultimately, when an expert is submitting a report, they have to attest to their independence and impartiality, and they're also have to talk about how they are relying on the documents. And when you're instructing an expert, you don't want to be giving so many assumptions and essentially taking them away from the documents in front of them. It makes their job a lot harder when they are under cross-examination, and it also just generally undermines a case if you have an expert who's not been given the full story and has to use that to produce a report because it may be favorable to the client. So I think we just don't do it, and I think maybe it's luck, or maybe this is the general trend in the profession, but I've not come across another firm where I feel in a dispute that they have, expert shopped. Yeah.
Well, so let's see from the other side. So Simi, from your perspective as working in a expert witness firm, have you ever come across a counsel who, try to test your opinions before appointing the expert to see whether there will be beneficial for their client's case?
Well, it is not uncommon for lawyers to reach out to experts and ask how they would approach a certain problem or an issue. I think we have to first understand when they have several experts as option, it is quite said that those experts have the relevant expertise or they have the requisite knowledge, right? But it's a very pragmatic way of differentiating one expert and trying to identify the right expert for the matter, and that is through by understanding if they understand, by asking them how they would approach a problem. It is a way to understand if the expert understands the issues at hand and they have the relevant experience in addition to the expertise and the knowledge. It is also a way of testing the softer skills that Tom and Tala previously mentioned on identifying the good characteristics of a good expert, basically. So it's the intent is not to align or to figure out who is beneficial for the case, but the intent is to identify who's the right expert for that matter out of the pool of experts who have pitched for it.
All right, thank you. Well, so we heard about the process of picking the expert. We heard that expert shopping is actually not as prevalent as you might think after reading some of the online articles that I was reading while preparing for this. So now we have appointed an expert, and the next step is instructing the expert. So Tom, that one's for you. What are your key considerations when you formulate instructions for an expert witness?
Well, I think first off, they have to be very clear and unambiguous, obviously. They have to be precisely tailored to the actual issues in dispute. It's an expert report is a big undertaking, and if the instructions are not sufficiently clear and not sufficiently relevant, you can end up with quite a lot of dozens or hundreds of pages of waffle that's sort of on the subject but doesn't really address the actual points that the tribunal needs to decide. I think the instructions also have to be reasonable. So as counsel, obviously you want the expert to give an opinion which is favourable to your client. And of course, it's usually possible to do that in some way by framing the instructions in such a way and setting up an elaborate series of assumptions to channel the expert in a particular direction. But that's not, I think, a very good idea. I mean, it raises some ethical issues perhaps, but also, if the expert's report is based on instructions and based on assumptions that are fundamentally not realistic or not reasonable, they can easily be undermined. Don't forget that the report will be scrutinised intensely by another subject matter expert and the other side's counsel. If the assumptions and the instructions are not reasonable, they'll be undermined in cross-examination, and then you end up with a report that's fundamentally just not very credible and therefore not very useful to you.
Right, and now similar question for Simi. Again, from your experience of the other side, how often do experts actually rely on instructions? How much do they rely on instructions? And do you usually test whether these instructions are reasonable, or do you take them more as a given?
Well, the two broad categories of instructions, I would say. There are some overarching instructions which set out the scope or what is the key question that is posed to the expert, right? I would say these are broad. They should be sufficiently broad, which provides the flexibility to the expert to apply the relevant knowledge and skill and expertise. These are usually untested, and we rely, and because they're based on the legal case and legal case. But we're often at times asked to rely on factual matters. For example, which is very common for us, if you're valuing a business, we would be asked to rely on a certain management projections. We would definitely go and test it against the historical performance or how the market has been for that particular business. So we'll scrutinize it and we'll properly test it. And then there's sometimes instructions which are outside the expertise of an expert. For example, we were once asked to assess losses arising from supply of a defective machine, and there was a technical input that was required, like how much would the yield increase after the installation of that new machine. And that's a technical input and outside the expertise of a quantum expert. And we were told it's 80%. And in such scenarios, we'll try and consider to provide a range of possible outcomes. So in summary, some sort of a scenario analysis, and in the example I took, we provided possible outcome based on a yield of 50 to 80%. So the tribunal can pick which is a more reasonable technical input and how the losses would vary based on that input. So in short, yes, overarching instructions we usually don't test, but the factual ones where we can reasonably test, we'll try and test them before relying, and the ones that are not, cannot be easily tested, we'll try and provide possible scenario analysis around it. I hope that answers your question.
It does. Thank you. So I think that covers everything that I had on the instructions. So moving on to the next stage in the expert evidence, preparation of the expert report. Tala, how much do you think the legal team should be involved at this step of the process?
It often depends on the expert. So if you have someone there's three things typically that lawyers should do, which is always to test the methodology, the analysis, the conclusion, to make sure that as a lawyer who is a layman and for let's say a quantum expert or an oil and gas expert, you understand what's being said, and that they reflect also discussions that have been had with the expert about the topic. We typically like to establish clear timeframes for when we expect drafts to be produced and preparation for hearing and everything like that. And lawyers tend to be quite involved as well in the back-end work, which is to ensure that the report is accurate. So experts themselves have their own quality checks that they do, but lawyers also will then take the report, kind of not tear it apart, but go through it as if it was one of our own submissions, site-checking it, checking every single document has properly been relied on and interpreted correctly. And I would say that the level of involvement just varies on who the expert is. So let's take the example of somebody who is an academic, who hasn't really had much testifying experience or experience producing these kinds of reports. We would not be leaving, we wouldn't be leaving things till the 11th hour. We'd have much earlier deadlines. We'd have much more frequent discussions about how the preparation for the report is going and how the views are developing. And it's just a lot more hand-holding. And we have had experiences where in these scenarios, someone who is a perfectly fine expert basically wasn't familiar with the process, and very much happened that at the 11th hour, colleagues of mine have been working really, really hard, essentially redrafting it into a way that makes it coherent, but still obviously sticks to what the expert was saying, and you just never want to end up in that position. But one thing which is overarching, regardless of who the expert is and what you're doing, is to always think of matters of privilege. I mean, we're in the UAE here. This isn't really always a concern, although it tends to be with arbitration. But in places like the US or the UK, you have to be very careful about exchanging expert drafts because some of those might be disclosable. So there have been circumstances where we've been advised to be very careful, or we advised experts to be very careful. And it's something where you might discuss at a Teams chat, or online or in a meeting physically, so that you're kind of protecting the process of the expert before the final draft is actually produced. So yeah, I think, as I said, it comes down to the expert.
All right, and now, again, what is your perspective, Semi, from within an expert witness practice? From your experience, how involved are the legal teams usually in the process of drafting? And then also, do you prefer the teams that are more hands-on, or do you prefer where the council sort of steps back a little bit and lets you do everything you need to do in preparing the report?
Well, interesting question. First of all, definitely hands-on. Once we get engaged, we tend to continuously engage with the legal team, and it's not uncommon to share draft reports at regular intervals. And the intent is basically to make sure that we are aligned with the legal case, which is very, very important. And we've not overlooked any material piece of information, or we've not misunderstood any material fact in the case. Having said all of this, I think lawyers' feedback is usually very well received by the experts, as long as it is on the form and not the substance or anything to do with the expert's opinion. Lastly said, it's always a pleasure to work with a hands-on legal team, and to continuously engage with them, because that can avoid any last-minute horror story that we all must have experienced at least once.
But then, so you prefer more hands-on approach, but were you ever in a position where it was a bit too hands-on? And as you say, maybe the pointers from the legal team were sort of going a bit further than the form and touching upon the substance and opinions, and you had to push back a little bit.
Not very often, but yes, we've experienced sometimes that where we had to push back lawyers. It's probably not as an expert opinion, but a certain factual instruction which we may not agree with. It's probably inconsistent with the legal case, or it's inconsistent with the other evidence we've seen. And so we'll try to explain that and process that out, that it's in the inconsistencies. In case there's still a reluctance from the lawyer's side to let go of it, or in fact there's insistence to include such scenario, then we would put that as a scenario, additional scenario or alternative in the report, and probably add some language around it which is clear and states that it's not an expert's opinion but an instruction that we're following. And tribunal and lawyers who are used to working with experts would clearly pick on this and may not provide as much weightage, but we do end up in such situations, and we do end up providing such scenarios in the report.
I think yesterday when we were discussing this, Simi was saying, well, sometimes, and I think we forget this, these disputes are emotional for certain people. So someone can have in their mind that actually I'm owed X amount, and whether they've calculated it correctly or they've inflated it, there's always that emotional aspect. And so I think it's obviously a lawyer and an expert's position to push back, because it's client management. You can create an alternative scenario if you really are pushed, but ultimately, you need to manage the expectations. I think you've been put in that situation before.
That usually happens at the initial phase of the project, where you get engaged and there is a very strong view of the client, what the nature of the breach is, or what the loss of the value of the loss is. But as you go along the process, I think counsel and lawyers are very receptive to the fact that expert opinion, which is well balanced, which is defensible in the courts in front of the tribunal, is far better than a very high or a very low unreasonable loss value, which is not defensible at the end.
Thank you. So we started discussing and bleeded into the issues of independence quite naturally, and I think we'll focus on these for the rest of the session. So Tom, a question for you. What are the checks and balances that are in place to prevent expert bias and ensure expert independence?
The checks and balances. So I think the checks and balances are generally very effective when it comes to cases of actual bias by an expert. I think it's very rare to have an independent expert who has some kind of financial or material interest in the outcome of a case, because you have expert declarations, giving evidence on oath, conflict checks. That sort of scenario, it may happen, but it's extremely rare. What certainly does happen, not infrequently, is for an expert to obviously want to support their client's cases as much as they can, and that can lead them to be a little bit overzealous in their conclusions, and therefore they overstep the bounds of strict neutrality. The difficulty is that the checks and balances tend to be soft. No one's going to go to prison for that. It's primarily a reputational issue. But I think they although the checks and balances are soft, they are still generally quite effective. Because as an independent expert, ultimately your reputation is the most important thing you have, and that's what you trade on. And if you develop a reputation for being essentially a hired gun, you're not credible, you don't have integrity, you're just going to be a mouthpiece for your client's arguments, you're very quickly going to lose value in the sort of expert marketplace. And I think unrealistic and unreasonable opinions, an expert can say anything, but if it's not realistic, if it hasn't been clearly thought through, and if it's not a reasonable perspective, then it will quickly be discovered, because, as we've mentioned before, there will be scrutiny from the other side's counsel, there will be detailed examination, cross-examination. The report will be scrutinized by another subject matter expert on the other side. So it's quite difficult to get away, I think, with just taking a partial and unreasonable view. And because of the reputational consequences in the long term, generally we say that the best experts, reputable experts, are sufficiently incentivized to self-police.
Simi, when you work on expert reports, do you have any of the checks and balances that Tom mentioned, or other checks and balances that maybe he didn't in mind?
So early in my career, I was working with an expert who told me that the tribunal will probably stop reading your report after the executive summary. The other side's lawyers would probably just read the body of your report, but then there will be an expert on the other side who will scrutinize the body of the report, the appendices, exhibits, sources, with a microscopic lens, right? So this very close scrutiny from the other side's expert acts like a very strong tempering force, and we tend to implement self-policing like that Tom mentioned. We would make sure that the approach we take is well balanced, the assumptions we take are very well supported. Where we can't support them or it's a matter of instruction, we highlight that very clearly in our report, and the conclusions that we arrive at are defensible. That's all, basically. So that's my key point on check. There's a very inbuilt check in the entire process itself, which is very effective from an expert's perspective.
Thank you. So you both, I think, mentioned that you think that the checks and balances are in fact effective. Just out of interest, have you, to all of you, has any of you ever been involved in a case where you saw clearly biased expert, sort of from the start to the end, and how did it go for them? Or is that just not really the case because the checks and balances are good and it doesn't really happen?
I would say I haven't come across that, but I have seen a scenario where two good experts had different conclusions, and I think the reason was their instructions. Like you are instructed, you're given certain documents, you're asked to make certain assumptions. That's where the difference comes along. I don't see it arising out of an inherent bias or a deliberate bias, or maybe you want to believe that those assumptions are realistic or reasonable, but I've not. Maybe it's still in my future, but I haven't come across that before.
Well, let's hope not. But yeah, I wanted to sort of get to that question, and I think, Simi, you're representing the expert witnesses here, so that one's for you. So if we have effective checks and balances, how does it happen that two experts instructed on the same case by different sides have very often, and I think that we've all seen, wildly different conclusions, coincidentally aligning with their client's case?
Well, like Tala mentioned, it's not representative of bias. There are several factors that contribute to diametrically opposite conclusions by the opposing experts. And the first one that Tala mentioned is completely different instructions, right? We were in an expropriation matter where we were asked to value the business one day before the date of expropriation. The other side's expert was asked to use hindsight and use a current date valuation. Now, these are two ships sailing in the night, right? They cannot be, they have to be two very different conclusions because the instructions are so different. And then there are other different factors. There's different interpretation of the case. There are instructions around factual matters which are disputed and in line with the legal case of each side. Then there are different interpretations of the macroeconomic factors. As damages experts, we're often asked to, forecast what the world would look like in the next 5 to 10 years. And there is plethora of information around there on the projections. And while it may be reasonable to use one option over the other, it doesn't mean that the second option the other side used is unreasonable or wrong. But it can lead to different conclusions. And lastly, the implementation of finance principle itself is very subjective. Discount rate is the most disputed topic in arbitrations, and it can be calculated using several methods. There's CAPM, there is built up, and none of those are wrong as long as it's defensible, as long as your assumptions for calculating those are well supported. They will be well received by the tribunal. But to answer your question, there are several factors contributing to the different conclusions and not just bias.
Thank you. So coming back to checks and balances, we discussed a couple of mechanisms that prevent expert bias and ensure independence. I wanted to discuss one potentially additional one, and that one is for Tala. Do you think that experts should not only disclose the previous engagements they had for a specific client, but also the previous engagements by the same counsel, since as we discussed, the legal team is sort of like the first point of contact and has a pretty important role in selecting the expert?
I have to admit that I've given this a lot of thought, and I don't really come out on either side. I think it's usually not a requirement, and I think that's for a reason. It's not seen as something that's necessarily going to sway an opinion this way or the other. And I'd probably use just a healthy dose of being sensible. If you have worked with if you're an expert who's worked with the same counsel for 10 engagements in the past year, and that's something you think the other side will pick up on and scrutinize, then yes, first of all, think about whether you should be taking the instruction to begin with. But if you do, then yes, disclose it. Otherwise, it does look a bit weird not to. But if you've had a couple over the past several years for unrelated matters, different clients, then I don't necessarily see the relevance. We have, as Tom said, experts have checks and balances on their independence, and then lawyers themselves are also bound by ethical rules. So ultimately, if the insinuation there is that, they work together and there might be some sort of bias or, questioning of, either party's independence, or especially the experts, then, I think that should be what's front of mind. If you think there might be an issue, then fine, disclose it. But otherwise, I just don't think that it should be a mandatory thing.
Do you agree? Semi, do you share Tala's views, or?
I think I agree with Tala's views, and the fact for anything to have an undue influence or to reflect bias, there should be an element of materiality. And if there are repeat engagements, or one expert is getting repeatedly engaged by a particular law firm, it doesn't really necessarily establish materiality, for example, right? For example, FTI might be engaged by a particular law firm 5 times in last 10 years. Probably repeat engagement, but not material enough to have an impact on the financials of FTI as a professional service provider, or for the Freshfields, or for the law firm, because it's a client paying the bills and not the law firms who have engaged the experts. So basically, in my perspective, there is not necessarily a bias, or this disclosure wouldn't really serve a purpose. we've seen some experts do it, and that's purely with an intent to avoid any unnecessary line of cross-examination during the while providing oral evidence. And last but not the least, I think a repeat engagement would probably just show that the evidence of the expert was well received in the previous engagements, and that's why they want to be repeatedly engaged by the law firm rather than any sign of bias.
Thank you. That was the last question from me. So unless anyone has anything to add, then I just wanted to thank you for taking the time to participate in this and for your insightful opinions. And also, if there are any questions in the room, then yes.
May I borrow the mic for a while? Thank you.
Hi. Thank you for this discussion. As an expert witness, we usually receive sometimes, many times, missing information from the client. The problem is not with the instruction itself. Usually, as an expert, you would know what to do with the instructions. For example, we want to know what delayed the project. So you can understand from where it's coming. But the problem is with the information provided themselves. So mainly, as an expert, for example, also as a delay expert, you can say, all right, I know that my client or who appointed me does not have this type of information, which is like a schedule. But we know the respondent or the opposing party have this information. And when we ask the lawyers, please provide us this information so that we can provide our correct opinion, these information are not provided. So automatically, as much as you qualify this in the report, your report will be biased and somehow because of the missing information. But it is not shown in this way in any case I have been in. That's the main issue, I guess.
Well, that happens often. I wouldn't deny there are missing pieces of information. But then there are disclosure requirements where you can always ask for these missing information if you know it's in the possession of the other side, first of all. Second of all, there are sometimes gaps in missing information, and those are factual in nature. You don't have an evidence, but for example, an event happened. And you can and then that's where fact witnesses come handy. Because it's a factual matter that happened and they witnessed it and they're ready to provide a witness statement on it, and then you rely on it, and it's not unreasonable to rely on fact witness statements as well. Thirdly, to your point, of course, if there's a missing information and appears to be a genuine reason for missing that information or evidentiary piece of information, we would provide all the caveats in the report, and we'll make it a provisional. We'll say our conclusions are provisional and probably update that once we receive that information, but that's all an expert can do at the time.
I'm not sure if in your scenario you're suggesting that the people instructing you are deliberately withholding something from you, because as Simi said, there's many ways to get the information. If it's your instructing counsel or client who's deliberately withholding something from you, then I can see how it puts you in a difficult position. That's where you have to make assumptions, and then in cross-examination you'll be asked, because like Simi said, things are put into evidence, so you'll be shown something and say, and they'll ask, well, why didn't you look at this schedule? Didn't you have it? And I think the only thing you could say is no, or I don't think it comes off poorly on an expert. It actually probably reflects poorly on the client's case as a whole. So it's unfortunate if it results in not the best expert report, but I guess that's why you have all your assumptions and your caveats, and there's only so much you can do if you have an unwilling instructing counsel.
Yeah, I agree with everything that Tala and Simi have said. It's a frustration that I think we all share. It's not just for expert witnesses. It's definitely missing information is a frustration that lawyers have to grapple with as well. And to an extent, that's part of the job. And Simi's quite right to point out that depending on the court in litigation, certainly in arbitration, you do have the opportunity to make document requests and apply for disclosure of certain documents if they're held by the other side. Particularly in arbitration, you usually have to do some work to demonstrate the relevance and materiality of a document request. And in my experience, if the independent expert in their report can point to missing information, which would be really helpful and would affect the outcome of their analysis, then that's a really useful hook for your document requests. Depending on the structure of the arbitration, if you have, say, memorial-style pleadings first with an expert report, and then you go into the document production phase, having documents or information, categories of documents flagged in the expert report as being helpful, potentially helpful, to your client's case is a really good way of persuading the tribunal to then grant those document requests.
Thank you so much for the panelists today for their insights. My question has to do with complex investment treaty arbitration and international commercial arbitration, dealing with niche subjects, as you rightly pointed out. There would be a quite unfortunate situation and scenario which is borderline unethical or purely unethical, where a law firm would go and engage multiple experts at the same time in sub-jurisdictions quite obscure that there are only a handful, and by doing so they would be conflicting out these experts from the opposing counsel. And this is an extremely difficult situation. It's happened multiple times. So I was just wondering, how does one circumvent and navigate these waters, if not to the point of preventing this kind of unfortunate and unethical scenario? Thank you.
I knew you'd ask something hard.
Not on purpose.
I think that actually, I don't know if it's possible to really circumvent it. I think actually it's almost like a race to the bottom from both sides, because I think as soon as you know that there's an arbitration that's reasonably foreseeable, both parties really will know. I know there's a claimant and a respondent, but it won't come out of the blue. And I think actually both of them will be taking the same steps, because states, you know, they use sophisticated law firms, and investors, depends who they are, but very often will do the same. And I think they will be advised very, very quickly, depending on the subject matter of the case. And as you say, if it's complex, lawyers will know very quickly that this isn't something that will, easily cherry pick an expert, and there'll be tons of them. I don't know. It seems to me that it will be a race to the bottom. Who's going to get to all of the experts fastest? I'm not sure if you can prevent it from happening before an arbitration, because you don't even at that point have a procedural order in place. So I don't, unless there's some kind of legislative changes, I'm not really sure how it could be done.
Perfect, thank you. No, that's all. Thank you.
So here's one more question. I'll come to you after here.
Yeah, thanks very much, guys. It's really good. Mine's slightly different, but there's a bit of a slant on it. Litigation support from experts. So how far, there's various points to the question. So how important is it? And if one party perhaps pays more fees to an expert, how much of an advantage does that give that party? And in such circumstances, is it impartial or is it an unfair advantage?
I'm not sure. I mean, there'll be a minimum. I mean, a minimum amount that is acceptable to pay an expert. But ultimately, if you've gone out to various experts and sought quotes and are able to pay, I don't think that there's an unfair advantage if one party is paying an expert slightly more. I think that applies equally to law firms. I think it would take quite a lot for there to, something serious. Serious incompetence on the part of an expert or a lawyer or any kind of professional service provider for there to be any procedural difficulty or any procedural grounds for saying that actually one party has an unfair advantage.
Sorry, to add to that.
Yeah, sorry, my question was litigation support. So it's not just on the actual report, it's the peripheral support which the experts give. Yeah.
So I think it's a collaborative scenario where obviously the peripheral services, for example, as experts and working on we're constantly collaborating with the legal team on what the fact witnesses are looking like and how the draft pleadings looking like, because we're also in form relying on them, and there's a constant exchange of we're providing those services, but it doesn't necessarily show impartiality, or if you're paid for those services in addition to the expert evidence, because it's just a collaborative and part of the whole process, I think. Does that answer your question?
Yeah, no, it does. It's more towards sort of unfair advantage rather than impartiality. 'Cause obviously you're impartial, but it's more of if there's an unfair advantage. That was the angle. But yeah, you've answered the question. Yeah, thanks. Yeah.
So I'll step in to where the expert witness had again step out from the moderator role. So I was actually on a case last year in a hearing where the other side, where we sort of attended as a team, and when our expert was testifying, we're around with the legal team and sort of, could provide pointers, whereas the other expert attended alone. And I think this is the example that you might be. Yeah. I think it was helpful for the team, for the council, to have someone from the team supporting while the expert was on the stand and couldn't be communicated with, obviously. But I don't know if you can, you can say, go as far as it sort of provides an unfair advantage or wins the case. I think, again, like Tala said, it's the same as the legal teams. If you have a budget to appoint, a team of 10 lawyers who will be able to scrutinize every document, every line, whereas, you only have a budget to appoint a partner and one associate, there will be a difference, but hopefully the system in place sort of ensures that it won't weigh in too much. Maybe this is a bit of like an optimistic and idealistic vision, but I think that argument sort of plays a bit the same for experts and the legal teams. It's just easier if you can engage more people, you can spend more time on the matter, but ultimately the conclusion will probably not change of, for example, an expert report or testimony. It will just sort of make it easier and more helpful for the client / the council.
Thank you, and thank you for the really informative talk. It's been really helpful. Just a question on independence and checks and balances. Obviously, in the UK, there's sort of a practice note on expert witnesses and their behaviours. In other jurisdictions, for example, in America, it's sort of more commonly understood that the experts might be closer to the hired gun or the biased expert constrained or expert end of the spectrum. When you're doing cross-border arbitration or different cultural elements in arbitrations, is what the expectations of your clients and the expectation and your prediction of what expert the other side may hire, does that factor into your thinking about an expert that you would instruct? For example, if you're working on an American matter, might you go to an American expert who has a different interpretation of independence, for example?
I'm certainly familiar with the dynamics. I'm not sure that has ever really, certainly in my experience, it's never factored into the choice of expert. I don't know how, it's certainly a noticeable phenomenon. I'm not sure how much of a problem it is. For example, I've been involved in a matter before, a DIFC-seated arbitration, where we engaged an expert, like a very niche subject matter expert who was based in the US. but had a lot of testifying experience in the US courts. And there was definitely a bit of us kind of trying to rein him in, essentially. You know, he was fulfilling his brief as he saw it, and that does involve in the US being a little bit more, maybe a little bit less strictly neutral. That's not a problem, I think, because if you're in a position as counsel where the expert feels like they're too on your side and you're trying to rein them in, that's certainly not a problem. I don't think, perhaps if you were acting, say, in a US litigation matter or a US seated arbitration, maybe you would have a problem if you instructed an expert from say, the UK, who sort of restrained themselves more than was necessary in this different legal environment. Perhaps that would cause a problem. I can't really see it being an issue, though. I think as long as you explain clearly where the boundaries are, then the experts will respect that. So there are definitely different dynamics, but I don't think it's a major concern for counsel.
Actually, I've been involved in a case where a UK-based expert was appointed for a matter in the US, and I didn't see any difference per se in the approach towards approaching that case, or whether they acted more like an advocate than an expert because it was US-based. It was still a very well-balanced approach. I think the question that you asked, if you're in the US, you'll probably look for US experts. It could be more of a sign of making it more economical rather than having an expert who is less independent or more independent, sort of a thing.
That's great, thank you.
So moving to next question.
Thank you. That was great. Couldn't resist one question. So you talked about the checks and balances inherent in the adversarial system and how that encourages experts to be independent. And I'm a product of the system, and I agree with all of that. I guess I view, the ultimate check as the arbitrator's award or the court judgment. And in arbitration specifically, do you feel as if awards go far enough in terms of calling out bad experts or biased experts or experts who are prone to errors or misjudgments that the tribunal doesn't feel they can rely upon, in order for that award to be an effective safeguard in the arbitration process? Because I detect a lot of compromise when I read awards.
I've certainly read few awards that do talk about lack of rigor or lack of, or that it's not well supported. So but not to the extent where the experts have been called out as biased. At least I have not seen that yet. But if Tala and Tom have seen that.
No, I agree with Steve's observations. I think particularly in arbitration, there is a general reluctance by the tribunal to be too critical of anything in particular. I think they're reluctant to be too critical of experts. Not just experts, I think they're reluctant to be overly critical of obviously unreliable witnesses of fact, for example. I think the most damning criticism I've seen of an expert report, which was verging towards bias, but overall just not very good, was that the award barely mentioned it at all. It was essentially disregarded by the tribunal. I think it's very unusual for a tribunal to actually call out bias or sloppiness or anything. But I think there are clear reasons for that. It's an arbitral tribunal doesn't have the kind of reservoir of inherent authority that a court has. They are there as a product of contract, and ultimately they want repeat appointments. So there are good reasons, I think, why a tribunal generally takes a very measured tone to just about everything in the process. But yeah, I think it does sometimes give experts the feeling that there's a little bit more leeway in arbitration because they're unlikely to be directly criticised.
And I think sometimes there might not be much about it because, as I said, like the expert evidence is inherently technical, and I actually find that some tribunals really struggle with the technical aspects, such that they maybe some don't actually feel that they are in a position to properly criticize it, as opposed to a bad pleading or a poor legal argument, which is something that they are, more knowledgeable about.
Hi, I just have a question about when niche experts are actually conflicted. So as a niche expert, I'm a fund manager and ex-investment banker, so there are not many of us around. But then sometimes they, like one side would like talk to a lot of people, and for me, I would just say, okay, I've talked to them, right? So I can't do it for you because it's not like my full-time job anyway. But then as more and more such cases happen, I wonder when I'm actually prevented from working for the SI, because sometimes they do come to me and say like, hey, can you work on this? Like a trade finance issue or whatever. So in particular, there was one client who, there was the engagement letter, appointment letter exchange, but they didn't pay the deposit. So in that case, am I actually conflicted, or am I, I got some information because they have to brief me on the case, right? But I haven't acted for them. So can I work for the other side?
I think it depends on the actual dispute and what the rules are that govern it, including laws, ethical rules. Like we have, like as lawyers, we have a regulator that's very clear on when a conflict arises, and it doesn't necessarily result from money exchanging hands. It could really just be as a result of actually getting information, and that could have put you in a compromising position. So I think the main thing to look at is what are the relevant laws that apply to you, but then take it forward to what I had said previously in terms of experts disclosing prior engagements with counsel. It's also just a question of whether it's sensible for you to do it, and whether you're actually undermining a potential report that you provide if it comes to light that this happened. It's a very difficult position to be in, but if you have the other side saying, well, she actually was, she was appointed and didn't receive money, you'd have a whole, you'd be cross-examined on this. It would be a really big topic. Is it worth it for this, for this report? You could really prejudice the client's position.
So do we have more questions from panelists? We still have 5 to 10 minutes remaining for the session. So yes, we can pick up a couple of more questions. So if you have, bring it on. Let's make it more interactive. Waiting for more questions. I see there are none right now, though nevertheless, we can pick those questions during the networking break or during the off-session hours. So thank you so much, panelists, for making this session an interesting one. May I have a huge round of applause for our panelists. Now, I would request our panelists to accept the memento on behalf of our litigation forum. I would request Alexandra to come forward and accept the memento on behalf of our litigation forum.
Thank you. Thank you very much.
A photograph is here.
Sorry.
Yeah. Now I request Simi Sharma to come forward and please accept the memento on behalf of World Litigation Forum. Thank you for joining. Now I would request Thomas Parkin to come forward and accept the memento. Thank you for joining. Now I would request Tala Fahom to come forward and accept the memento on behalf of World Litigation Forum. Thank you for joining us. Thank you so much, panelists. Thank you so much. Now we will be moving to our next session. That is session 3, which speaks about force majeure claims in the modern connected world. And the panelist for the session, rather the moderator for the session, is Karolis Gudas, who is the Deputy Head of Legal Department, RB Rail, that is Rail Baltica, Lithuania. Then we have panelist Daza Epets-Drerier, who is the Managing Partner at Reed Smith LLP, Germany. We have Mohammed Noaman, who is a Journal Council Europe, Middle East and Africa, G Energy. So I would request our moderator and panelists to come over the stage and take it forward from here. Thank you so much. Please, panelists, I request you to come over so we can resume with the session 3. Thank you so much. So I would hand it over to Karolis to take it forward from here.
Thank you. Sorry? No, this one. Thank you very much. On a serious side, I hope Daya and Mohammed realize that we are the last ones standing between the lunch and the audience, and we will focus only on the fundamental aspects of the topic. And when preparing for the force majeure, I have remembered one movie. It's produced by a European filmmaker, Ruben Östlund. And the plot of the movie is very simple and straightforward. A European family, a wealthy European family, decides to go on a vacation. They have 2 kids. They go to Alps. They enjoy their time. First 2 days are excellent. They do some skiing, go to some nice restaurants, etc. On the 3rd day, there is an avalanche coming. What does the wife do? She looks where her children is, embraces them, and tries to protect. What does the husband do? He takes his iPhone and runs away. Then, suddenly, the wife realizes that her husband is not so loyal to the family, and she files a lawsuit for divorce. The husband pleads, it was force majeure. Avalanche. I had to protect my life. I should be released from civil liability. So I wonder, in that serious context, would the husband win the case? What's the concept of force majeure in Germany? Does he have a legitimate case? And how would that situation compare in Middle East? Daya, please.
Shall I start? Thank you. Yeah, that's an interesting story, to be honest. So maybe to start with the German concept of force majeure, we don't have any definition of force majeure in the law. So there is no regulation or no statutory law defining what force majeure is. It's different in many other countries or jurisdictions, but that's how we operate in Germany. So what you need is really a clause you agree on in contracts to define force majeure, like incorporating wars or pandemics or epidemics or now maybe even hyperinflation. But as I assume, like starting from there, that couple didn't have like something they agreed on in their marriage contract to argue what force majeure is, I think he has a hard case to argue. There are other concepts in German law, like if the base of a contract or the assumption the contracting parties had changes during the course of the contract, you might have a right to change the contract or like the main aspects of that contract. But I think it's hard to argue that in this case, like how to change a marriage to some different concept. So maybe that's from a German perspective to start with.
Yeah, I think it's a funny situation, right? But I think in the in the Middle East, resources of law is coming from the civil law systems and the latent laws. And this is always determined in the civil codes that force majeure is written as, it's not like Germany, it's written in the codes as unforeseen circumstances. But it's also a mix between what you said in Germany, because it gives the ability for the parties to agree on a specific events that could be determined as force majeure. So I think the unforeseen circumstances in the civil laws across the Middle East is talking about big events like war. Even the pandemic was not covered because the times when the civil law was developed in many, if it's not in all the countries in the Middle East, the earth did not see something like the pandemic that happened before in the previous 2 centuries ago. So this is why it was not covered, but the war is covered, and the other unforeseen circumstances that makes everything difficult, which give the criteria, and this is how the pandemic applied to this. And with this criteria, it does not apply to the marriage, for sure. And so unless you agreed on a specific circumstances as force majeure, as you said, then I don't think it will apply in the Middle East.
Right. Taking from that, I'm just wondering, what's the standard of proving force majeure in general in Germany and Middle East? Do you have to prove, let's say, objective impossibility as such, or subjective circumstances also are considered as force majeure events? Because usually, I understand that in ideal world, if you have a similar event like war, like avalanche, whatever, that you're not able to control, etc., it's easy to prove that the event has been external, you can control that, etc. But what if the nature is highly subjective? For example, a contractor cannot execute and complete the contract, the construction project or whatever, because the costs have increased a lot and the contract became not feasible to implement. Or let's say there was an event in some third country that has had an impact on the global supply chain, but the contractor had the possibility to subcontract from another country and get the equipment, technology, etc. to execute, but at the very high cost and not feasible terms. So would you say that subjective impossibility could be an argument for proving force majeure in Germany, in Middle East and other jurisdictions that you act in? Perhaps we can start with Mohammed.
I think the legal theory of the force majeure is the most, in the Middle East and the civil law systems, is the most subjective theory that you can find. Because the laws is usually given a high-level perspective on the criteria and given example of it. But at the end, the criteria is very wide to allow the contract parties to look at a specific case-by-case events happened. There are things that doesn't comply with the criteria, and in order to make sure that your criteria is working efficiently with your event, you need to keep this in mind when you do your pre-contract stage. And the example you gave about the construction, for example, if you are going to do a construction project in a greenfield, and then you did all the inspection on the greenfield site, you cannot claim force majeure for things that you didn't know about, like the land cannot be done with this construction, blah, blah, blah. But and it will apply the same if you have the obligation to do that, the inspection, and you didn't do it. But if you don't have the obligation to do the inspection, if the normal contractor wouldn't do the inspection, and then you find something unforeseen that you cannot know by the simple knowledge of any engineer taking the project, it could be something that is perceived as force majeure. Financials are totally different, because anything comes to the profit and losses has to be examined by both parties. So if you entered into a contract and this contract doesn't make money, the only person that you have to blame is yourself, because you did not calculate your financials correctly. It's not a force majeure for sure. But again, the criteria is very flexible in the civil law system. They give you a lot of things, and it's very, very, very subjective. Not sure about how Germany will see it, but yeah.
Thank you. Yeah, actually, I fully agree with what you say, because we are a civil law system as well. So it's always decided on a case-by-case basis. So it's an individual argument you have to provide to the court or to the other party to start with. And I think, yeah, as you say, it's very flexible, yeah, but you have to provide really direct arguments. So you cannot say, like, for example, I was affected by, or I'm affected by the Ukraine war because the supply chain changed and we didn't receive certain product. That doesn't work. So you have to specify the Ukraine war had an impact on the supply chain with a direct contractor of us, and we didn't receive A, B, C, D, E, F, G, and this is why we couldn't supply like our other contractors. So it's and then the court has to decide whether you could not have, for example, received your products from other companies. So you need to like look for other possibilities to really minimize the damage you have received. So that's the general concept. But as you said, it's like individual case-by-case basis, and the German courts are very strict on really confirming force majeure. We had some cases based on COVID where, for example, tenants could not pay their rent, who had like hotels, for example, or big stores who could not open during COVID, and then argued that they could not pay their rent. In some single cases, the courts confirm force majeure, or that they could claim force majeure, but it was only in rare ones. So in general, they didn't accept that argument. As you said, with regard to construction contracts, it's the same in Germany. If you price for something, it's your risk moving forward that you will make some profit in the end. If you just didn't calculate in a good way, or didn't take into account probably future changes or prices, that's at your risk. I don't know, it's, I think, interesting to wait what is happening with the high inflation. We spoke about that, like, as a preparation. You have like a super high inflation in your country, in Germany. We are struggling as well. So it remains to be seen whether courts might take into account. This is now a very specific situation with a very hyperinflation, like also companies could not foresee, so there might be some adaptation to the price. That remains to be seen, but I think there could be an argument to be made. Everything is okay. Yeah, thank you. Would you like to add something?
Yeah, I think in the inflation part, I will give you an example with a country like Egypt now. The inflation affects it very, very much. Currency versus USD is devaluating very big. So now, contracts, if you have a contract with the government, it's in dollars. And now the country is saying, I don't have dollars. So either you shift it to EGP or Egyptian pounds, or I will claim force majeure. And this debate has been for the last 10 days now. And everyone concluded in this, in the arbitration side, experts and everything. No, it's not. It's not a force majeure. It needs both parties to consent to amending the currency payment or the payment terms in the agreement. I think I would add on also one point with relation to the criteria and all that stuff. One of the big challenges in the subjectivity of the force majeure is the sanctions. So if you take an example of sanctions on Russia recently, or even when you have the nuclear agreement between Iran and the US. And then when President Trump came, he canceled the agreement and he put more sanctions on Iran. And this made the US countries, the US companies, unable to deliver its obligations under the previous agreement. And then the US companies came and said, it's a force majeure. However, after 2 or 3 years in arbitration, this has been proven, no, it's not force majeure. Because it's one-side decision, and you cannot harm the other party in a contract because you have to comply with your own regulations. So you cannot benefit from this. So I think those sanctions now is coming every day, and those kind of challenges, it's going to be the next debate on the force majeure subjectivity.
I have to say, I would have shared both of your viewpoints 1 year ago, but now I think I have a different opinion, just for the sake of the argument. Last maybe 7 to 10 years, I have been in charge in the front of responsibility of implementation of really large-scale infrastructure projects implementation, and also acting as a counsel in some disputes, including on force majeure. And in fact, the trend on the threshold of evidence was, as you said, you have had the obligation to demonstrate that there is some sort of objective impossibility, etc., because there has to be a huge event to apply force majeure, etc. But what I have noticed recently, and also in Lithuania, that courts tend to reduce the threshold of evidence for the force majeure. And I'll give you one simple example. There was a COVID case on tenant agreement in Lithuania. It went up to the Supreme Court of Lithuania, and Supreme Court of Lithuania has applied the modern contract doctrine and said that force majeure does not require to prove only objective. It can also, a party can also prove force majeure with subjective elements, such as substantial shift in contractual balance, such as substantial shift in economical situation, commercial situation of one or another party. And going into this argument in greater detail and reading literature and the latest academic articles, I realized that there is a global trend to reduce the standard of proof for force majeure and enable the parties to rely on force majeure on basis of some subjective elements. Do you share this viewpoint, or
I think it's it's very interesting because the force majeure disputes is usually also subjective. You need to differentiate between individual disputes and those disputes that involve governments. So of course I'm very biased to my business because for my entire career, I was the GC for GE Aviation, GE Aviation, GE Healthcare, GE Oil and Gas, it's all government where we're dealing with. So if you look at those contracts, where it's not an individual contract, it's big, because and usually it's arbitration, and the tribunal and arbitration is usually looking at it because saying that, okay, you as a government, you control the events, usually. If you're talking about events like COVID, if you're talking about a country like Iraq, in the middle of the pandemic, they said, no, it's not a force majeure, you need to deliver. And there is no airlines to deliver anything, the ports are closed, everything is closed. Then the arbitration tribunal has to make a relief order to say, no, this is because you're the government, you're strong, you're saying that you have to deliver. No. But in the individual world, there is a flexibility more than this, because the contractual positions of both parties is mainly going to be a little bit equal. But in your government contracts, it's not equal, I can tell you that.
Okay, question I have, what's the industry practice in general? What kind of events are recognized as force majeure events, according to the best of your knowledge in your area?
I think mainly the air traffic. I think the board's accessibility, the ability to clear goods, the ability to deliver within a secured locations. And secured locations means if you are in a war or militias or a declared war zones, civil wars, all of that is going to affect the security delivery. I think anything related to your deliverables timelines that can affect and apply the LDs. This is mainly in the industry that I work for, which is the energy industry or aviation or whatever. Healthcare, of course, as you know, spinned off from GE. But for those industries, in general, the main thing is your ability to deliver within your time schedule. Suspension of anything that can limit your ability to deliver is going to be a force majeure by either the government or the actual circumstances. Don't forget that sometimes the government is saying that it's a national security order, no one can enter this place. Finish. Or circumstances. But there is always the gray area. For example, if I give you're shipping things to Iraq, or you're shipping things to Yemen in the Middle East, and no airlines going to fly to Yemen to take your shipment with them. This can be a force majeure, except in one case. If there is a single airline that's going to ship, and then the single airline has a lot of shipments to do, and the schedule is very busy, and you have to stay behind the line. And this is where your interpretation of maybe it's not a full force majeure, but I cannot also meet the schedule of deliverables because I have to wait, and so on. So there is sometimes clear cut in the industrial practice, in the deliverables, and sometimes there is a gray area. Dear.
I fully agree, but maybe going back one step to what you asked us regarding whether there is a shift to confirming more force majeure cases. In Germany, to be honest, we didn't have any in the recent, 20 years, maybe, because everything worked fine economically. So there was one case when you went to university, and it was that you rent an apartment in the street where a festival is coming to go by, and then that festival is cancelled, And then it was said, okay, yeah, then you get back your rent and you get back your money you paid for that apartment, because it's like, to some extent, force majeure. It wasn't claimed force majeure. It was said, okay, the circumstances changed so much that there was an adaptation needed to the contract. So that was the case we always had in Germany, because there were no other cases decided by the German courts. And now recently, I think we had many economic worldwide, like COVID, we have now the Ukraine war, we have inflation. So there's a lot of disruption leading to the courts trying to support companies, but also individuals, like with the overall scenario. And this is why I think that there is like a tendency to support more the force majeure argument, rather than maybe because there wasn't so much need for in the past. Yeah.
Yeah, I think it's reasonable to take as a benchmark, let's say a professional contractor who could have foreseen some certain, circumstances. And if one ends in a situation where there are a bunch of events that a professional contractor could not have foreseen, I think it's a natural shift of the courts to support the companies in arguing force majeure cases. I think it's a really good argument from a German perspective that for 20 years you have had a stable economical, commercial environment, etc. Now it's changing, and the changing economical and commercial environment, the interpretation also changes. And going from that point, I have a question. What's the general culture of claiming force majeure? Because let's say from my experience, I noticed that if you work with Eastern European contractors, they may claim every single external event. If there is a sanction, you will get a notice, a claim, and you may end up in litigation. If there is another event, in the next few days, you will again get a notice, you will have to litigate, etc. When working with some Western companies, I noticed that irrespective of ongoing external events, facts, they don't claim. They just try to sort out the problem, and once they fail, they come with a claim and elaborate the case. If negotiations are not successful, then you have a case before the arbitral court or court in general. So what's your experience with claiming culture of in connection to force majeure events? Can you elaborate?
No, I think you have to differentiate between usually a one-time customer, a one-time contract, and a long-term customer, long-term contracts, government, country, whatever. So on the short-term relationship with customer or a one-time contract, usually you enter into a discussion, if you will, and then you go to litigation. In the long-term customer and those governments, if you will, it's a 25 years contract. So your last resort will be the arbitration or litigation in general. However, you need also to keep in mind when this dispute arises. Is it at the beginning or at the middle or at the end of the contract? In your long-term customer relationships, it doesn't matter really, except in the execution side. And I'll give you an example. You contracted with a country to provide electricity through gas turbines. And gas turbines is burning natural gas to provide you with electricity. It's high voltage, you cannot use it, then it goes to transformers so you can have this. And it's a country where they ask for financing. And the financing that is going to provide them with this is a UK Exim Banks. And the structure of doing this is, for those lenders, is to sign off everything. You have the obligations in place, contract signs, everything, and then the financing starts. You signed, what, $500 million deal. And then the lenders came and said, you know what, I'm sorry, the regulation in the UK came out 1 day ago, and there is no financing for fossil fuel. Sorry, you have to do clean energy to finance. And then you go to the customer to say, you know what, there is no financing, there is no money, there is no project. And then the customer says, no, you signed your obligation, I need the electricity, find a way, why don't you finance it? And I said, no, I'm not a finance company. So he said, no, you need to discover it. And then this kind of discussion and dispute at the beginning of the contract can perfectly leading to litigation. Because at that level, and you are at the beginning of the contract, you didn't sign, you don't have a lot of choices, if you will. Either you find a solution, you enter and continue the contract and execute, or you put it in arbitration. And usually you start with mediation, try to get some experts saying that it doesn't apply, blah, blah, blah.
Maybe starting from where I'm coming from, I've been doing litigations for nearly 15 years, so litigations and arbitrations. When I started, we had like the financial crisis, Lehman crisis, and I was a junior associate, but I did all the briefs, and then I came up to my partner saying maybe we could claim force majeure in one of the litigations. No, this is not going to work. This is like an argument we don't use, and this is like only if we're very desperate, so we shouldn't use it. So moving on, and now in the recent years with COVID and Ukraine, it's coming more and more popular to in contracts, but also to use it in briefs, and not because we are desperate, but because it's really an argument we think is a good one, and we want to test and develop the law to make the courts motivate and encourage the courts and to assess really firmly whether this is force majeure or not. So I think that there's definitely a shift that this becomes a popular argument to use based on different developments we had, and I think this is also what you probably experience in your day-to-day business.
I just want to add something. I think this is very important point you said, because I think for the last 25 years, litigation, depending on force majeure claims, was minimum. And the COVID was an eye-opener for this side or this area of the civil laws. And because of that, we saw the trend of our business teams is coming and saying every couple of days or couple of weeks, can we claim force majeure? Before that, we didn't hear this term at all before the COVID. So it started to become, and it started to also give more ability to interpretate the scope and the criteria of the force majeure. I think everyone at the back of their mind before COVID, they were thinking about civil war, delivery, stuff like that. And now, no, there is an area for legal minds to interpret more into the scope of and criteria of force majeure going forward.
I remember once having very tough negotiations on maybe 150 million euro settlement deal, and one associate level from London office, Magic Circle firm lawyer came and in the middle of negotiations and said, look, if we prove force majeure, we will have a right to terminate the contract. If we terminate the contract, the project will fail, you will be responsible before the government, blah, 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 etc. All these arguments. And back then I wondered how responsible is to use the word termination in a large-scale project that is in the middle of execution. And I thought that these words could be said someone who is, working in a capacity of a consultant, but not someone who is driving the project and, trying to ensure that things are done. So turning from, the viewpoint on the concept and regulation of force majeure, I want to ask you a question. What are the consequences of application of force majeure? If we assume that force majeure is applicable, what remedies can we reasonably argue and achieve?
I think mainly it will be on the schedule of deliverables. I think it's gonna be if the force majeure makes the contract impossible to execute, given the fact of a timeline of providing the services, then it is termination, and the termination will be without the termination fees. And the termination in force majeure will bring the parties back to the point where as if they did not contract. So they will be back. But you need to keep in mind, whatever you executed, you will lose. You're not gonna, they don't claim damages, but also you cannot claim what you execute if it has money value. But at the end, if this is not the case, then I think the main remedy is to the contract, once the force majeure occur, it has a stop point. Stops in everything. And then it restarts again from where it started after the force majeure finish. And this is going to affect, as I said, the LD or liquidated damages ability to apply. It will affect the schedule, it will affect the deliverables, and then most probably it will affect also the termination fees, because in the other side of the first example I gave, which is the impossibility of the contract, if the contract become possible, but it has to be after the force majeure, because the force majeure, and the criteria of this will be if the force majeure is a temporary event, or is it a continued event for unlimited times? And by the way, a lot of people in the COVID, they claimed impossible to execute because they don't know when it's gonna end. But if it has some timeline or time frame that this will end as a force majeure, then this is a good remedy of not terminating the contract, especially if you are at the supplier side versus the off-taker. And it will give, as I said, stop point of the contract, and then the contract will start again to execute after the force majeure.
Yeah, maybe looking at it from the contracting parties, I think like stop or really terminating a contract is the worst outcome for both parties. And even maybe litigating it or arbitrating it at a later stage is like good for the lawyers, but not really good for the companies, because it's like all costing money. So I think the best outcome would be if you can agree on some kind of settlement after the contract has come to a stop to the force majeure event, but then trying to adapt the contract, maybe agreeing on later timelines, or maybe looking for different companies to support you, maybe making the contract work. So trying to negotiate and not really saying, no, we are terminating, because that is definitely not in the interest of both parties. So trying to really sit at a table and mediate. Maybe we are often now asked, not only in force majeure cases, but also in many different aspects of disputes, to support the parties with coming to a settlement, because companies try to avoid litigation or arbitration because they just see it's a lot of money they have to invest. So I think this is definitely a shift, what at least I see. I've never done or have never attended so many settlement negotiations than I do at the moment, and try to really find a good outcome, or outcome both parties can live with, or even sometimes more parties are involved. But they're just trying to find a way all parties can live with.
But imagine, just one point, imagine in the COVID situation, and the contract as it stopped, force majeure, and everything is paused. Then it's resumed again after the COVID, but everything changed. Prices changed. Commodities changed, timeline of delivery changed, everything changed. One party of the contract, for him, this contract is a lose-end contract and a loss from a profit perspective. So I think with this, sometimes, this party will come and say, no, terminate. I take a short loss and I go. Better than I continue and I try to deliver for you something that is going to be 5x of losses.
I fully agree, yeah. There are definitely cases it's better to terminate than to just keep going.
Okay, I want you to comment on few situations. Let's take, situation number one, you have a contractor, you have employer, both of them have made a heavily investment in the construction of some, power plant or, any other construction project, and suddenly everything changes. The contractor realizes that it's going to make a net loss, it's not feasible to implement the contract from commercial standpoint, etc. On the one hand. On the other hand, the employer realizes that if the contractual price has increased by X percentage, then it's not worth implementing the project at all. At this stage, you have both the contractor and the employer under huge uncertainty. They don't know what to do. And the time for the award of the arbitral tribunal is too long, like 2 years. While in those 2 years, you have to implement the project, or otherwise you will face LDs and other consequences. So the first question is, what kind of advice would you give to the parties in that situation? And the second question is, I recently learned that force majeure application now, bears the consequence, at least in some jurisdiction, of the right to revise the price, the contractual price. And I have read some lower court case law in Lithuania, and I wonder, is it the same in Germany and Middle East? Can you argue, let's say, force majeure as a legal basis for the price adjustment? And from that point, we will move to our final topic and conclude the session.
I think it's for the first question, when things goes south like this, I think if you're an in-house counsel, or if you are an outside counsel asked to advise on a contract, it's good for both to look at the dispute at the time before contracting, when you drafted a contract. You try to, we usually come and say, okay, we're going to have English law governing the dispute resolution of the contract. That's fine, but you need to have full assessment on English common law before you go to this contract on those clauses specifically. Not only limitation of liabilities and all that stuff, but also in force majeure, unforeseen circumstances, raising the prices, all of that. So, because I think we have to keep in mind that force majeure is not a public order. Force majeure is a civil law practice and legal provisions, which means that it allows the parties to agree and disagree. And you have to be careful when you're drafting your contract on this. And with this, you have to keep in mind things very bad can happen. And if you cover yourself by giving a space to the international market changes to reflect into the contract, that will be good. So this is my main advice, which we try to do it in all the time to anticipate that the world is not that perfect and things cannot be stable for 20 years or 10 years. Change is the norm. So be careful about that and try to always give yourself some space to at least enter into negotiations. It's not termination or continue, as is. At least to have some space. I think with the consequences of the application of force majeure, I think yes, there is consequences on the relationship with this customer, if you will, and I think also there is a big debate now about, do we really want to go to force majeure application? But I think if we go back to the question regarding the litigation application of force majeure, there is, any contract has two parties, right? So you're thinking about your force majeure, the other party is always thinking about it. So what I saw for 2022 negotiations is that majority of customers and the other party sitting at the other side of the table is trying to be more specific in the contract on force majeure, excluding some, including some, and that's it. We don't want a vague interpretation.
Thank you. I like your point about when you have like a disagreement or a situation in a contract, going back to why you agreed on a certain, choosing a certain law and what maybe the parties agreed on or disagreed on, what they discussed. And I will also say if you have like a situation where it's not working the way you expected it to, change the people who have been involved in the case. Just have somebody else involved from your company or your legal team looking at the case and see maybe they have some different argument, a different approach. You don't always have to ask like, your outside counsel just at first, but just trying the setup, different people, different team, and try to have another meeting to see what you might be able to reach or to come to. And regarding your question about adjusting prices, yes, for sure, that's what the German law provides for an adaptation of the contract, not like a termination in general, but definitely for an adaptation of prices or delivery. And that is what we have a lot done with clients and agreed on in the tenants area, in the rental space, agreed on reduced rent to be paid by certain companies during COVID. Yeah, that they were extended, that they had a longer time frame to pay for, or reduce the rent. So that's definitely a common thing, and I think it should be used. Or if you can agree on something like adaptation, it might be better than a termination, as we discussed already.
You know, in my practice, I realized one thing, and at some point I have enforced an internal rule. And my learning is that if you have complex negotiations, let's say, in a gray area where both parties are acting under huge risk, uncertainty, etc., and if you hire, let's say, external consultants who support you, it's more likely to end up in arbitration with external support instead of a situation when you negotiate internally with the in-house team. And at some point I have, enforced the rule, not to bring any external law in the negotiation room, and only once it's clear that we are at the edge of dispute, only then to engage third parties, because I learned that, besides those issues that are behind infrastructure projects, there is also a huge commercial interest by law firms, consultants, etc., all this industry that we have here. But going to the final topic, we don't want to stand before lunch anymore. I just want to touch the final aspect, which we have discussed with Daya and Mohammed separately, on distinguishment between force majeure and hardship. And it was interesting for me to learn from Mohammed that there is no such institute as hardship like we have, let's say, in Baltics, which we call in Latin language rebus sic statibus. So I want to start with Daya and ask her to elaborate. How do you distinguish force majeure and hardship, and what would you recommend the client first to start with hardship claim or force majeure? What is the difference? Maybe you can explain to the audience.
Yeah, sure. Actually, I asked her when we spoke that we don't really have hardship. I didn't know what hardship was, and that's like, okay, yeah, we have like a similar institution in German law, like the adaptation of a contract if the circumstances change or shift to a different responsibility. And as said, force majeure is not regulated under German law, so it's only if you've agreed on a specific clause in a contract that you can use it really as a claim. But most contracts, like in the business sphere, contain such a clause. So again, I would always, depending on the circumstances, but as Mohammed said, if you have long-standing contracts, I mean, it depends on the case. If you have a clear-cut force majeure case and you can really, there is impossibility, you cannot deliver, you cannot pay, I mean, and you are clear, okay, we have to terminate this contract or have to put it to an end, then claim force majeure. But if it's like not a clear-cut case and you just would like to adapt and stay in the contract and would like to keep the relationship, then I would definitely not go for force majeure and do the hard tour, but try to negotiate and try to find a settlement. But this is really up to the individual circumstances, the case, the client. I mean, it's not always me just counseling the client, but it's like so important to know, okay, what's business-wise also needed or required, or what the aim we want to get to. So I think it's like a very individual case.
I think the hardship concept itself, we don't have it. However, we have only one principle, which is the impossibility of executing the contract for reasons behind your control. And when I said impossibility, means the contract has to go away. It's not partially impossible. It is impossible because it's either losing one of its main principles of the three principles of the contract, like the price and the its and the parties' ability, or because, and I didn't want to mention this when you asked me about changing the profit and losses as criteria or equation between the parties, because I know that we're coming to this. Imagine one situation where you enter into a contract and the only way to deliver the contract is to become bankrupted. This is the only example of it's not a force majeure, but it makes the execution of the contract impossible for you. Not for the country, not for the site, not for the deliverables. You can deliver. So it's not a force majeure. You can deliver your obligations, but you will bankrupt. So you can claim at that circumstances that the contract became impossible for you to deliver. However, you will be subject to damages. It's not going to be and the difference is force majeure is, as I said, you stop the contract, the clock stops, and then it starts again after the force majeure goes away. In this, it doesn't stop. It will end, and then you will be liable for damages if you didn't execute. However, the liability in damages will be reasonable. You cannot be liable for the value of the contract. Otherwise, you will deliver it, right? You cannot be liable for the whole damages of non-executing and find another contractor and execute it at your cost. No. It will be average damages, but you will be liable.
While studying hardship, I noticed that many civil law jurisdictions have regulated hardship and codified through civil codes or some special laws, etc. While in continental law side, I noticed that there is a general concept called frustration, the doctrine of frustration, that partly resembles and substitutes hardship that is acknowledged in civil jurisdictions. My question to both of you, and this is the final question, are you familiar with frustration doctrine? Is it applicable in your jurisdictions? If yes, what's the general burden of proof?
No, it's not in the Middle East. I don't know what is Germany.
It's like, again, we have this concept of adaptation where you can use it, but it's not like stipulated as such. Yeah.
Okay, with this, I think we conclude this wonderful session with wonderful presentations. And thank you very much, Mohammed and Daya, for your time. And if anyone has a question, one or two.
Yes, we have a couple of questions. May I borrow the microphone? Thank you.
Hi. Uh, I understood all this concept behind force majeure and hardship and everything. But how about if we go for like what happened like 10 years ago, 12 years ago probably, where there was a sudden and extraordinary increase in the steel prices worldwide. And there is a principle called for the prince also, which falls under that you cannot execute it because it's not under your control and responsibility. However, many aspects similar to this affect the financial equilibrium of the contract, which not necessarily going into full hardship or full frustration, or a force can be categorized as a force majeure. How do you deal with that in this aspect? I mean, the financial equilibrium has been, or you lost the balance of this financial equilibrium in the contract eventually. How do you deal with that in this aspect?
Yeah, please, Mohammed.
No, I think it's the same like my last example. It's a very interesting situation. What happened 10 years ago also, there was, I witnessed a couple of arbitrations for this itself. And mainly it was from suppliers. And because it's not only for construction, it's also, it was for manufacturers' ability for many other things like gas turbines, jet engines, stuff like that. And it was accepted as impossibility of execution. Not a full hardship, not a force majeure, but because at that time the financials is not making losses, it was extreme losses. And because of that, the tribunals in many arbitration courts determined that this is impossibility of execution. Or otherwise, as I said, you can do it, but some of the companies, if they did it, they will be like bankrupted, or they will have a huge financial hit, and it will affect everybody, including their employees. No termination. No. Damages was because in this specific example you gave, thanks to you, it's a supply example, right? Usually the contract did not start. The contract was to supply. And the damages at that time was on the delay side of the deliverables. And usually this kind of deliverables doesn't have like 3 years deliverable times like others big equipments. It's for manufacturing, and because of that, or continuing a construction site or something, it has short time of delivery. So when that happened, either some of the suppliers were delivered already 50%, 25%, but they cannot continue, or others didn't start. In both of them, I don't think there was damages. I don't recall that, but I don't think so.
Maybe, probably under German law, we would also come to impossibility, but we could claim damages. So I think the one who didn't receive the supplies and had to get the deliveries to a higher price could claim the difference between like both prices, but only if the other party was liable. So that's like, then the other question, was that party liable for not foreseeing? Then again, some force majeure comes into play, actually not foreseeing that the steel prices would happen, but there would, at least it would be assessed whether there could be damages claimed. So maybe in this case, they will also come to the conclusion that there wasn't any because they were not liable, but that would be dependent on the specific case.
But did you see what Dara mentioned was the contract become impossible? It could be because of force majeure. You see this link? Yeah.
Yeah, just to finish, maybe. I think it's a very good question.
Just to expand on that, there's been a case in the UK, Rockcliffe Hall. It was a golf club that suffered during the pandemic, and the business interruption insurance policy declined to give them the compensation due because of the wording of the policy. So some insurance policies, very limited policies, did make payouts to businesses. As you can imagine, sums went into millions of pounds. And like again, the insurance business could be bankrupt if they had to make payments out to everyone. So majority of people did not get the compensation due to them just based upon the wording of the contract, which I'm sure in time will be appealed. But you know, the decision on Rockefeller was that it won't be Rockcliffe Hall, sorry, I should say, it wouldn't be proceeded with. And so that again is of concern, you know, when a business needs the compensation that's due to them and they paid the full premium. Some people go for the most highest premium to say, I want everything covered, but then the disease clause declines to cover new upcoming, you know, pandemics that they're not aware of.
Absolutely. I think if you look now specifically for the insurance policies, now a lot of insurers are discussing in the negotiation of the insurance policy the scope within pandemic, within does it cover business losses or not. It's not like before. You did something wrong, you did not deliver, there is a problem with your equipment, insurance covers you. No, they're talking now in the insurance policy about the global events that has no control, which was usually completely excluded before.
Hi, just a quick question. Oh, sorry to cut you off. I was just interested, in Australia, we have unfair contracts legislation within each of the states, which really does serve to supplement your force majeure arguments, and we have doctrine of frustration in Australia as well. We certainly saw a resurgence of force majeure arguments, not necessarily cases, over the last couple of years. I'm just wondering whether in the Middle East and Germany and perhaps Lithuania, whether there is something similar to unfair contracts legislation that's incorporated as well to sort of act as a sort of supplementary to those doctrines.
Just a question. So unfair, and then you say you can negotiate and not terminate or adapt the contract. Is that the consequence?
The unfair contracts legislation actually serves to allow the courts to intervene and either require one party not to enforce performance of the contract or not to enforce a termination clause or a damages provision, penalties and the like. It's most commonly applied in circumstances involving a major financier or a bank. To say that the bank's terms are unfair. Don't have that.
No, actually, yes. It's a big yes. The majority of the, it's not majority actually, if you look at the whole Middle East region, including even Pakistan, they have the unfair contracts amendments, and you have to apply for the court, and and when we say the court, it means the local jurisdiction court. It's not dispute resolution agreement. You have to go to, it's a public order, you have to go to the court. The court is usually asking for an expert opinion, and then they have to decide and award. And their decision is to amend the contract. It's not termination, by the way, because you cannot go for termination for unfair contract, but you have to go for the contract, for the court to amend it to make it fair. Usually also, it's mainly when you contract with someone very powerful, like a state, like a government, someone that you don't have a room to negotiate the contract, because you are the weak party. So in this kind of things, the jurisdiction gave it to the court to step in and said, I'm your lawyer, I will make it for you because you're very weak, you cannot do it in this. There is no equality of parts, exactly. The balance of equality between the parties. Thank you. Good question. Thank you very much.
on this question, let's say in Lithuania and in Baltics in general, I don't think we have a similar legislation as you have in Australia, but we have some civil code provisions which you can rely on to challenge unfair clauses, but that's a difficult case. On a general note, I always note the following, that let's say in FIDIC yellow book contracts or in state contracts or contracts that have been prepared by monopolistic companies like large-scale companies, multinational companies, etc., there are always huge risk transfers to the contractor side, right? Sometimes unlimited. Sometimes, you know, the contractor is requested to undertake the risks that it's not aware of and it's not possible for the contractor to foresee in the future, etc. So in those cases, irrespective of the fact that there is no legislation, usually the courts and the arbitral tribunals step in and try to bring some rationality within the framework of the contract, irrespective of the fact that the contract, let's say, attributes unfairly all possible and imaginable risks to the contractor. So therefore, we have, let's say, a court or the tribunal that tries to bring some sense to the contractual relationship and steps away from the contractual interpretation. Ideally, one needs to have a law, but if there is a similar case, I think that's the duty of the court and arbitral tribunal to have a little bit of balance in the relationship.
So do we have more questions? I think we don't have. Nevertheless, we, as Catalyst said, I also don't want to come between you guys and lunch. So with this is a wrap for the session 3. But before that, before I conclude the session, I would request our moderator and panelists to accept the memento on behalf of World Litigation Forum. And I would request Catalyst Gudas to rather present the memento to our panelists. All right? So, Catalyst, yes, if you could please. I would request Daya Apitz-Dreyer, I'm so sorry, to come over and accept the memento on behalf of World Litigation Forum. Now I would request Mohammed Noaman to please come over and accept the memento on behalf of World Litigation Forum. I would request Catalyst to please accept the memento on behalf of World Litigation. Please, can you come? Oh.
That's okay. Lawyers never.
Well, we have force majeure then.
Yeah, maybe. Yeah. Thank you for joining. Thank you so much, panelists, for this wonderful session. With this, we come to the end of session 3. But before we move to session 4, we will be moving for a lunch break for an hour and 15 minutes. The lunch is on this first floor, that is Medley Restaurant, and we will meet again at 2:15 p.m. for the rest of the sessions. Meanwhile, enjoy networking and enjoy your lunch. See you at 2:15 p.m. Thank you so much, everyone. I have it. Yes, I'll play it then. Hello, everyone, and a very good afternoon. I hope you all had an amazing lunch networking break. You made a couple of friends, colleagues, partners, and a lot more. So that was the intention for us to organize this lunch networking sessions. Now, not taking much of the time, we will be moving to our next session, that is session 4, which speaks about regulatory developments in anti-money laundering. And the moderator for this session is Andrew N. Hart, who is a partner at Hart Giles, Solicitors and Notaries, Hong Kong. And we have our eminent panelist here. We have Sabina Noreen Malik, who is a consultant solicitor, negotiation expert, Alexander James Solicitor, United Kingdom. We have Harish K. Som, who is a general counsel and senior director, United Arab Emirates. Then we have Farhat Ali Khan, who is a managing partner at Century Maxim International LLC, Dubai. So with this, I would like to welcome our moderator and panelist. And from here, I would hand it over to Andrew to take it forward.
Good afternoon. It's good to see so many people in the audience. I'm only joking. But hopefully more people will come in once the speeches start. And it gives me great pleasure to introduce Fahar, who will introduce himself and give the first presentation. Thank you.
Good afternoon. Thank you for having me here. This is a topic which is, of my interest. I enjoy talking about this. This is a very, very developing topic in the legal practice. Until now, this was more of a financial services related topic, but it's picking up, in the legal fraternity as well. So my background, I'm a lawyer from India. I've been practicing as an in-house legal counsel, as a private lawyer in different territories. We have an office here in UAE, a firm registered with ADGM, known as Century Maxim International, and we do a lot of corporate commercial work. AML is now a very widely discussed topic, and it is going to become our day-to-day operational matter in terms of business, in terms of disposal of any client activities, whatever. And I regularly have a debate, discussion, argument, whatever we may call it, with my MLRO when I'm questioned, on onboarding clients without having verified the credentials, without doing a proper KYC check, without having proper UBO documents, without having, done the regular checklist that is required for AML compliances. We all understand as lawyers what are the different stages of money laundering, how money laundering, is a challenge at international level for different governments, for different agencies, for different regulatory bodies. And as legal professionals, we play an important role, to ensure regular checks in terms of prevention of any, such incidents which could be a potential violation of AML laws. Governments have come up with different regulatory frames that we'll try and discuss. So we quickly did a small presentation. So I thought I'll run you guys, run the audience through this whatever work we've done, put it on the slides just to share what's happening on the AML front in within the legal fraternity. Before I go on the slides, Andrew, is Harish or the other panel members also going to introduce, or I just go on the slides?
You do your presentation first, if that's okay, and then I will ask them some questions, or they can present afterwards.
Or
if that's all right.
Maybe maybe the panel members can introduce and do some initial.
Yes.
Yeah, and then I'll just run the presentations. Yeah, Harish.
Thank you, Farhad. Thank you, Andrew. Good afternoon, everybody. It's very difficult to hold a session after lunch, so I'm not sure. So 2 sessions just before lunch and after lunch are critical sessions to hold. My name is Harish K. Som, and I have been a corporate lawyer since I think it's more than 2 decades now. In my stint, I worked with various companies. I have been a general counsel for various companies in India and Middle East. Just to quote few names like Coca-Cola, Carlsberg, Americana, IFCO. So I work with these companies, and of late I decided to change side, go to the other side of the table and settling down myself into a practice just to taste that fruit as well. So that's about me.
Good afternoon, everyone. I'll keep it short and brief. I'm Sabina. I'm a lawyer based in the United Kingdom, and I'm here today speaking at the World Litigation Forum on regulatory developments in anti-money laundering, which I'll discuss after the presentations have taken place. And if there's any questions whilst the sessions are on, please do put your hands up. We're open to questions as the panel is speaking. You don't need to wait until the end. Thank you.
So Andrew, as I go with the slides, would you be also asking me questions, or it's only the audience?
Depends what you say.
Okay. So I mean, as legal professionals, we all know what stages of money laundering is. What is how this entire process works. What is placement? What is layering? What is integration? How dirty money is brought into the system and then used for different formats of investments and high value purchases. So that's a very basic definition of money laundering. But now with more and more technologies, more new ideas are being implemented to bring in something by the perpetrators of money laundering into practice. So, and to deal with it, the global authorities are there, which have been founded in 1989. The FATF, which works as an international watchdog with respect to AML. High-risk jurisdictions under increased monitoring with respect to trade and financial activities, financial dealings. So it is our responsibility, it is a legal responsibility on business professionals, on financial professionals, on legal professionals to see when dealing with entities originating from different jurisdictions with respect to whether it is a high risk or a low risk and what kind of checks are required. So with the basic definition of AML and the FATF, now we have the global program against money laundering, which is referred as GPML. It provides an in-depth assistance to countries to build and strengthen their AML frames, the laws to combat anti-money laundering. And this is a body that has been constituted under the directions of the United Nations General Assembly, and it provides a continuous support on technical and other regulatory assistance to the member states. It is also supports to achieve target under the UN SDGs. That calls upon by 2030 all member states to significantly reduce illicit financial flows, strengthen recovery and return of stolen assets. So this more or less particularly relates to AML violators who fled from one jurisdiction to another jurisdiction and placed their wealth, which has been obtained through proceeds of crime in different jurisdictions. So there are some latest developments on the AML fronts that's happening in different jurisdictions. So the UAE has different regulatory authorities, that combat, that deals with working to prevent any money laundering, terrorism financing, which includes the Ministry of Economy, the Central Bank, the ESCA, known as the Securities and Commodities Authority of UAE, the Ministry of Justice, the Dubai Financial Services Authority, which is in the DIFC, and the ADGM FSRA, which is the Financial Service Regulatory Authority in the ADGM. So, and then we have independent courts now established in the UAE. So there is a dedicated court in Abu Dhabi, in Dubai, which only conducts trials and proceedings of matters related to money laundering. And soon we'll have independent, and possibly we may have independent investigating agencies, independent prosecuting agencies dedicated to money laundering violations. So, and then there are some recent, matters that have been that have come up, where the court recently convicted some citizens, of committing crime related to tax-based, U.S. tax-based evasion operation. So similarly, we have, in India, which is the authority there is the Directorate of Enforcement. That is the principal authority to deal with any violations or offenses related to money laundering. We have in the Singapore the corruption, drug trafficking, and serious crimes. The Attorney General Chambers in the Singapore conducts direct investigations in matters related to under the law related to corruption, drug trafficking, and serious offenses in Singapore. So, of course, we all know what's happening in the EU under the AML laws, under the FCA guidelines of UK, and of course, how the US is continuously bringing in more and more regulations, combating and dealing with matters related to anti-money laundering. So there are some recent violations. And these recent violations would indicate that how financial institutions are getting penalized. And when they get penalized heavily, it means that there is a direct hit on their P&L, which means the financial institution, the bank, or a company engaged in financial services would have to pay a lot of money and then go back and fix the flaws with respect to preventing any kind of money laundering. So one of the recent cases that happened in Delhi, there was a cryptocurrency exchange, named as Wazir X. So the directors and everybody, they were put under detention, put under investigation, and the entire exchange was shut. This involved hundreds of millions of dollars, right? So there are authorities that are conducting investigations in different parts of the world, and now this is becoming more a global coordination between agencies where information is being shared and the agencies support each other of different jurisdictions in terms of dealing with perpetrators of one jurisdiction who have fled to another. So there are some latest reforms in the UAE. So in 2022, the Central Bank of the UAE issued new guidance for licensed financial institutions on digital identification for customer due diligence. So these are activities which now it is important for financial institutions to ensure that all data, all identification of customers is integrated to the UAE identity network. Yeah. So and then of course this is with respect to banks, financial companies, exchange house, insurance companies, agents, and brokers. When we say brokers, not just financial brokers, brokers dealing in other assets as well, particularly real estate, they are also under serious compliance requirement to ensure that there is prevention of any type of money laundering, whatever they suspect, and must be reported immediately. So some investigations, and these investigations not just relate to financial services, real estate brokers, designated non-financial service providers, other professionals, and professionals are also under radar. Could also come under radar. One more thing I always say, to my audience and my clients, that down the line, corporates could also require to ensure a day-to-day operational compliance to AML in terms of dealers, distributors, channel partners, third parties that they deal with, to ensure that their channel partner, their dealer, is not trading, is not dealing with any banned organization, with any banned individuals. So there is a regular compliance check that is required in all commercial activities, including financial, real estate, and other business and professional services. That's it. Andrew, you got any questions? For me or the audience?
I would be interested to know, what is the outlook for UAE going forward? Do you see that the regulations are going to be more strict going forward? Because you've seen at the end of last year, there's new legislation coming in.
See, when we do a comparative analysis between the regulations and the laws that have been introduced in the UAE, it is far more progressive in terms of money laundering than other jurisdictions. There are multiple authorities, institutions. Like for example, in a particular country, there could be a single authority which is end-to-end responsible for anything related to anti-money laundering in that particular country. But here in the UAE, the respective authority, like the ADGM, they have their own set of regulations. Even though they are governed by the federal law related to anti-money laundering, the regulations require any entity, any individual dealing in that particular set of services to comply with the regulations. So ADGM plays its own role. Parallelly, to support the federal frame of the legislation. Similarly, DIFC would play its own role. The Ministry of Economy would play its own role. And these roles are independent, parallel, and supports the federal frame. So UAE has really progressed, and there is significant development in the past 2-3 years. And the way this development has come up, it seems that the intention is to improve it and cause a continuous improvement.
Farhad, I think in addition to that, what specifically we notice in AML laws of UAE, which is very smartly done, which is something which is a very sort of smart effort by the government. Say situation would have been different if we talk 4 years before or 5 years before what has been the situation in UAE, but that has completely changed with the advent of that new amendment into the AML laws. The best part which government has done is they have expanded the definition of funds. And when you increase the definition of funds, so what they have done, they have brought into pictures of many other things which people were playing upon. They have brought into picture of digital currencies, letter of credits, order for payments, shares, everything is under definition of funds. Also, the cryptocurrencies also are all digital currencies, everything is coming into a definition of funds. So nobody can play away or do anything with their money now. So everything is regulated and controlled in a very efficient and efficacious way. So that's something which is the best part which government has done. And over the period, I believe that UAE, especially the situation in UAE, we are learning from the world, and situation is improving because the coordination, the effective coordination is happening between the agencies. In 2021, we have a dedicated federal agencies for AML and CFT. And as Farhad also said, we have a now dedicated court who specifically address and adjudicate these matters related to AML. So what I believe situation is improving a lot, and we are walking as per the requirements. So we are learning from the world, and UAE is amending whatever and whenever something is required. Including cryptocurrencies into picture, I think is a very welcoming step, which I believe a lot of countries are missing now. So that's something which we should be proud of.
Can I just ask, Harish, you said that you've been practicing for the last 20 years or so. How do you compare the situation today to how it was when you first started your practice?
Pathetic. I'm sorry to use that word, but technically when I started my practice, I initially practiced also in India. Then I moved in-house, and when I was working with various companies, so what I believe is money laundering is a byproduct of the smart people behind, right? So money laundering is what? Money laundering is siphoning of funds and transferring money by evading taxes from one hand to another, right? That's why we have a concept of tax haven countries and money safe countries. So it's a smart work or good advices by the people in terms of how to structure the transaction. The recent example we have is in UAE itself of NMC Healthcare and Abras, that investment case which happened, in which they got a huge fine from the authority. So these things are coming. So money laundering is coming, how you structure a transaction, and how you transfer money just to show to the government that is a proper fair play, but technically it's not. Money has moved from one hand to another and changed countries, but on the paper you want to show that everything is very plain, vanilla, fair, and everything has been complied with. So to answer to your question, Andrew, the things have drastically changed over the period. Initially, things were not very regulated, not very structured. People were doing multiple things. Tax lawyers were advising something else. Transaction lawyers were saying something else. Government believes in something else. So departments, people were not speaking or they were not in sync with each other. But I believe over the period, because people have started misusing all these sort of gray points, gray areas. So authorities have also strengthened their norms, their regulation, and we are moving in a right direction. That's something which I believe. But nobody knows the future, right? So, I mean, the other side is always smarter. If you regulate, for example, crypto into this, so there are many ways and means by which people will find out other options, right? So we have to live with the requirement and we have to keep moving. So as I always believe that every law, every regulation is a living regulation, right? You can't fix or can't make that static on that particular moment. That has to improve or that has to get amended with the requirement of the time.
All right. Sabina, would you like to? Yes? All right. The only other question I had is, in UAE, for both of you, do you have the rule that you're not allowed to tell your clients if they are being investigated, or if you suspect that they have committed an AML offense?
So, AML offense, if there is any detection or any suspicion that arises on an investment or a fund that has been brought in, which could be suspected as a proceed of a crime, so the first thing that a compliance or a MLRO is required to do is to ask for details. And if the compliance officer, the MLRO is satisfied that this is certainly, a proceed of a crime which needs to be reported, it has to be reported very, very confidentially to the appropriate authorities, to the agencies, to the banks, to the financial regulator, and to the investigating authorities. So these investigations under no circumstances could be disclosed to a party, to a person that is being investigated.
Yeah, and plus there's a requirement in ML laws which I believe is very good, because technically it casts a duty on a particular person, which is on any entity, whether it's a financial institution, non-financial institution, or even professionals. If you come across with any suspicious activity, that becomes your duty to report to central bank, and they have a dedicated portal for that. It's a whistleblower portal which they have dedicated only for these specific activities. So it's a duty casted upon all the stakeholders to comply with this particular requirement. So periodically we are supposed to file that suspicious activity report with their particular division in central bank.
All right. And the last question I have for both of you is, in terms of your work that you do in your practice, do you find any trouble or conflict with your duty as a solicitor with your duty under the AML legislation?
Most of the time it happens, Andrew. I will be very straightforward, very candid, and very open about it. And that's the duty of a general counsel, because having worked with companies for a large number of my life, so I believe that's a duty of a general counsel to strike a balance. A general counsel has to be pro-business, but at the same time, he should be advising and counseling or mentoring management and other stakeholders like CFO and other people that what is right, what is wrong. There are a lot of contrast cases. There are a lot of cases in which general counsel is put on a very sort of sticky wicket that management wants to do it, board of directors wants to do it, then you have to get it done. But that's where your role will come into picture and play, that you how you will strike a balance between management wish and your duty, right? So you have to make everything compliant. A lot of time we get gray areas and maybe out of ignorance, people are not aware within companies, but we have to advise them right. So yes, of course, there are a lot of situations we come across which is non-fully compliant with AML or completely in contravention of AML, but at the same time, we are there in that position for that reason only, to make everything work, both ways, compliant way and also the business way.
Farhad, do you have anything?
See, these kind of situations are, you get to deal with these kind of situations, and then when you have these kind of clients approaching your firm, there are certain requirements. There's certain checklists to be complied, and if they do not comply, it is always advisable not to onboard such clients. Under the Proceeds of Crimes Act of UK, where law firms are now under strict compliance to ensure that they ask all the right questions with respect to verifying the source of investments, funds, income, whatever a client comes up with. So, it is becoming more and more, part of our day-to-day client onboarding process. And certain times we have to say no to clients that because you do not, you're not able to, clarify, or you do not qualify with our checklist requirements, so we can't, we have difficulty onboarding you. So, yes, you get to deal with, and then you have to be with a clear no to clients who are not able to validate, confirm their credentials.
I agree with that. In the UK, property law is one area where money laundering happens quite predominantly. And so the indemnity insurance for that area for conveyancing property transactions is always much higher than other departments. And I've had situations where clients have overpaid money on account, and at the end of the case have had to refund it. But again, I have to ensure that they give me a trail of where the money came from and how it was sourced into our account, and then I have to send it back the same way. And if a third party is sending the money on behalf of my client, I have to reject it because it has to be the client source. You don't know if a third party is trying to launder through your client. So yeah, in the UK, the requirements are very strict, and we have to follow the tick list. Otherwise, the SRA do come down on you quite heavily, which is the Solicitors Regulation Authority, our governing body. That said, I'm going to just go on to developments which are quite interesting to me in AML, and I'm going to touch upon crypto investments, which is the latest craze more so since the pandemic, I would say. It's a high growth area, and there's been very few regulatory safeguards, especially with the recent collapse of crypto assets and the surge of litigation that's about to begin. It's a volatile product, just like stocks are in the stock market. And Coinbase, Desk did make a comment to say that it's a bubble that's bursting, and the NFT craze is burning itself out. Stable coins are now beginning to collapse, and the crypto lenders are beginning to go bust. Crypto is potentially, as they would say, in a bear market, and that was a quote by CoinDesk. You've got to be in an investment that's fair and not risky, but in the crypto environment, they've exposed themselves quite heavily to riskier investments than they had anticipated. And the industry just grew rapidly overnight at a pace that the regulatory bodies have struggled to keep up with. And the momentum that's surrounding this has come to a stage where it's now at a halt, and the product's beginning to decline. And so governments are coming together from all over the world to address this issue and keep measures in place to keep the reporting and the transactions. And given the complexities, the litigation and arbitrations are likely to grow generally in a rapid way. Because investors were induced to invest their hard-earned money into platforms such as social media influencers coming on and promoting products, false statements made by companies promoting those products, artificial inflation of prices at times, and the USA, the company named Binance has already been sued from my readings, and crypto exchanges and financial advisors are potentially at risk now. Crypto assets, there's been about 200 actions from around May 2022 in the USA, with UK likely to follow behind, and more than likely then UAE will too. And as I say, it will be a claim for mis-selling. It's a low risk, well, mis-selling for saying it's a low risk product when it wasn't, and misleading the investor by saying that there's assets to back this product. For example, it's backed by the US dollar, and there was no proper regulation in place, so regulatory fines for those companies potentially could be insufficient for the losses that have happened. And the investors are not benefiting from the regulatory protection, unfortunately, because the regulators have not been able to keep in pace with how fast this industry's grown. And so the courts are likely to be quite sympathetic for the investors, because they've lost potentially millions and millions of dollars. And it could mean that we hit something like the 2008 global crash. And the pattern may be similar in 2023 onwards. That's something that we will have to keep an eye on and see how hard it hits. And so what we've got to understand is, under these uncharted territories, funders coming into these claims will think it's quite a lucrative market, and so litigation funding is likely to grow. And again, that's a separate body that's regulated. And with regards to crypto development and proceeds of crime, crypto exchange providers will have to conduct risk assessment more highly, set up adequate AML contracts, ensure that their customer due diligence is done more heavily, that they monitor transactions and business relationships properly, that the staff receive proper training, and they spend ample sufficient funds on that training to mitigate the risks within the business. And they've got to retain the records to show exactly what they've done to minimize those risks. And if the product's unregulated, which technically this crypto NFT assets, they are unregulated products, which are going to be regulated. And as rightly said, Andrew, it will be a slow process. It's developing. We are going to find lots of loopholes as the time goes on, and they will be covered as time goes on. And so, it's a fit and proper test. If an applicant wants to be involved in this type of product, they need to register themselves with, for example, the Financial Services Authority, which would be the regulatory body in the UK. And in the UAE, there are AML guidelines with regards to handling money if it's been laundered. And the three main regulators in the UAE are CBUAE, which is onshore Dubai Financial Services Authority, and the Financial Services Regulatory Authority, which is the ADGM. So with the cooperation of certain government departments coming together with the competent authorities, and so long as they implement the right policies and regulations to control the issuing of any licenses and permissions, for example, in the banking sector or the non-banking sector, then things can progress and this can be targeted quite hard. But the thing is, no institution can be at the same level at the same time. And so the way forward may be to adopt technology to stay compliant, which is more of an enabler than human resources. It costs less. You can automate the product, and there's less of a backlog. So when cases of AML are going through the system, they can be backlogged potentially, which, if automated, can be dealt with much quicker. And again, in order to execute this, of course, you will need human resources, and it's just making sure that the industry potentially train the staff up properly and spend proper money on the training and not cut back. So that's my little take on that. I hope you've enjoyed listening to it. And if you have any questions, you're free to ask at the end.
I'll just update you very quickly, even though I'm supposed to be the moderator, just about Hong Kong, because it's an interesting jurisdiction for a lot of people, particularly recent developments. And the position here is that 20 years ago, I remember that there was the old airport open 25 years ago. People used to bring suitcases full of money to deposit in the airport bank that was just next door, and nobody said a word about it. And that's one indication, I guess, of the change of the development in Hong Kong, whereas you have a duty to report. I think, as Sabina said, the biggest problem of the authorities is they don't have enough resources, because there are so many reports made that they can't actually deal with all of them. And most lawyers, the sensible advice would be, if you've got any idea that there could be a problem, report rather than don't report, because you can't get in trouble for reporting, but you can get in trouble for not reporting. There are a number of people more in the audience now. It'd be interesting to have people sharing questions or views, because I'm sure that AML is something that applies to nearly all of us on a daily basis. Has anyone got something they'd like to contribute? It's the challenge after lunch. The thing that would be interesting for us is that we've got UAE, we've got UK, we've got Hong Kong, but if there are any other jurisdictions where you come from that you know about, it would be interesting to have a comparison there to see where the position is changing.
I would be interested in knowing what's happening in the Arab world, maybe in Egypt, maybe in Jordan, maybe other jurisdictions, how the AML, legislation, the regulatory frame is progressing.
I know there's a gentleman in the front row who's from a bank in Egypt, so...
the stories behind the AML is not interesting at all. They bring you to the present, so that is not interesting at all.
No, going forward though.
But the matter in that is lots of challenges happening in the market, because to the extent of the exposure going to the direction of the technology, you find a lot of pressure and challenges with regard to the anti-money laundering, because the time that you are going for the direction and the development of the technology and the development happening in the digitalization and the challenges surround, it makes a pressure for the governments and regulators in order to put a proper regulation, in order to have a proper regulation for the anti-money laundering market.
Anybody else from this area?
We would love to hear your experiences of your jurisdiction for the AML. Like, let's make it, I know it's lunch, which is to the whole, like, the effect of it. But of course, we would love to hear it from all of you, like, any experiences or any comment or anything.
All I can tell you, another story from Hong Kong, is that there was, probably 30 years ago, there was a big insurance company that failed in Hong Kong, and that insurance company was one of the companies that was insuring solicitors' indemnity risks. And as a result of the failure of that company, the Law Society made solicitors go to risk management education. And one of the big elements of the risk management education is AML. The only difficulty is the Law Society produced this practice direction about anti-money laundering, but unfortunately, whoever wrote it had probably had too much lunch, and it didn't make a lot of sense. But the thing that I think that is the big concern in Hong Kong, following the UK situation and example, and I don't think you mentioned it, Sabina, but I believe there have been a number of solicitors that have been put in prison in the UK for not following the correct rules as to reporting. Fortunately, in Hong Kong, I don't believe anybody has been convicted of that, but it must be a concern to each of you, whether you're in private practice, whether you're in-house, and it would be very interesting to know how your companies or your practices deal with AML, because I believe that it's a problem or an issue that is going to be a repeated issue, and as trading gets more sophisticated, Sabina's already mentioned about crypto trading, that was one of the ways before that people avoided being detected for AML because there wasn't the sufficient tracing, but I think that's being gradually addressed. But if there are any other suggestions or thoughts, this is a forum where we can all help each other, hopefully, to avoid going to prison. And it may sound an overstatement, but it's very, very easy to forget or not to make a report, and that then results in you being prosecuted that could be resulting in you going to prison. Yeah. And it's, I would say, of all the subjects in this seminar for these 2 days, it's the most, to me, it's the most critical issue. It may not be the most interesting subject, but it's the most worrying to me, because every time you pick up a phone or receive a fax, you are potentially going to be facing an issue that there is going to be somebody who is going to get you into trouble. And there is, and the panel members have agreed that there is a certain conflict of interest between your position as a solicitor with confidentiality or duties to your client, but the duties to your client are overridden by the statute by saying you can't tip off your client as to whether there's a suspicion, because otherwise you've committed an offence which is a bigger offence than actually the client has in the first place, potentially. So is there any other thoughts? It would be very interesting to hear them.
And this entire process, not just lawyers, by the way. In the US, there are many general counsels who are facing investigation when there are cases of corruption, bribery, and other kind of financial irregularities that have been detected or have been ignored by the general counsels of different companies. And particularly related to FCPA, particularly related to where companies have been involved in acts of bribery or obtaining contracts through illegal payments. And the general counsel or the legal counsels have ignored the in-house counsels. They have faced prosecution, and there are many such real live examples in the US now. Yeah.
Just to quickly introduce myself, my name is Ashraf Abdelhamid, the General Counsel of the National Bank of Egypt. The legal and compliance, they are both belong to the same family, and I used to work with some multinationals like Citibank and Intesa San Paulo. Some of them adopt the system of covering legal and compliance under the same umbrella, but now it has been splitted, the most, according to the corporate governance regimes and systems. But asking about the compliance, sometimes some regulations and jurisdictions, they split between the anti-money laundering and the compliance. Some of jurisdiction, they make it the same under the same umbrella. In your opinion, which structure is worthy to be adopted more? Thank you.
So one compliance officer's role, which was largely initially, very closely related to the legal department, and you normally say legal in compliance as one department, or one department will have two verticals, one legal, one compliance. So compliance is now becoming independent. With respect to the role and responsibility of compliance is to check, and make sure that the checklist is complete. Legal is with respect to ensuring that is there a violation of law that has to be checked. A new position is now being created and being developed, which is called the MLRO, the Money Laundering Reporting Officer. And the MLRO's role is now becoming more and more interesting in this entire scenario, where he would see if there is any violation, or if there is any suspicion, if there is any SAR to be completed, then he would immediately report it. So compliance and legal, they're now moving parallel, but with the common objective to ensure that the AML, any violation or whatever is prevented, and if there is any detection, it has to be reported immediately.
So it's regarding the compliance and legal.
Yeah.
But coming to the compliance and anti-money laundering, some organizations adopt the system of splitting both anti-money laundering and the compliance. Some multinationals are like Intesa Sanpaolo in Europe as well, as example, in Italy, they split between the anti-money laundering officer and the compliance officer. In your opinion, which one is worthy to be adopted than the other?
So I'll give you my example. I'll share my own experience working in a company with MNCs. I work with a major beer manufacturing company, which is a Danish company, so no need to name a company as such. So actually that depends on which jurisdiction you are based, what are the governing laws, and what is the requirement of law which you have to adhere to. For example, in India, we have a concept, or we have a role of company secretary, which is considered as an officer of the company. So he is the first compliance officer who's supposed to comply with each and everything, whether it's a statutory compliance. When I say statutory compliance, that means all compliances which are under the statute, all compliances under the secretarial activities like board meeting, management of minutes of meeting, and all sort of things, and also the compliances which are thrown by the legislation, by the various laws. For example, in India, which I'm sure is true with other countries over the period, that there are various local laws and various specific laws which you have to adhere to. Say, example of UAE, we have new ESG thing which has come into picture. We have now new plastic waste management rules which have come into picture, especially for FMCG companies. So question will come, who is supposed to comply with that? It's legal compliance officer. I've seen practically in my company, legal head says if there's a compliance officer in a company and he's reporting directly to the CEO or MD, and legal head is also reporting to the CEO or MD, they always shrug their hands. No, it's not my responsibility, that's his responsibility. It's a compliance, it's a plastic waste management compliance, so he's supposed to do it. Compliance officer will say, no, it's a matter of interpretation. I need advice, I'm not a lawyer, I can only comply with the documents. So it's basically an overlapping area. But ultimately, if I have to stress upon on the role and importance of a GC, so I think that should fall in the kitty of the General Counsel, because General Counsel is a pillar of the management, right? Like CFO, CLO, CHRO, we have General Counsels. And in most of the companies, in my previous companies also, the compliance officer was reporting into me. So technically, I'm also spearheading the compliance. Although I have a chief compliance officer, but that doesn't mean that everything is on him and he's only supposed to handle the things independently. It's also the duty on me to spearhead him, to supervise him. So technically, I think that should be the GC in my view. And in most of the cases I've seen, but unless law requires otherwise, unless law says that you should have a chief information officer or chief compliance officer, then that person comes into picture. So that's something which I feel is there.
Supposedly, the law does not prevent or prohibit having the compliance officer to be splitted with the AMLRO. In your opinion, what is the best practice in the world, to split or to cover it under the same umbrella?
I think all these areas are expertise areas. Especially, say if we talk about the concept of UK, like UK Bribery Act, or the US FCR, Foreign Compliance Practices Act, we have FCPA, sorry, yeah. So all these areas are expert areas, so that's the reason we have designated people there to manage those things. But when we see the responsibility sits on whose head, ultimately CEO or the directors, board of directors, so to say, and below him is GC. So things falls on the shoulder of a general counsel, but technically is handled by an expert person. Because GC or a CEO cannot handle everything themselves, right? There has to be expert person, and that's how there's a concept of an organization, right? In organization, we have various people, and everybody is working like a machine, right? All are parts of the machine. So I think that should be separate if a law requires or doesn't require, depending on what volume of a company is into, where they work, what are the complications of that area, and how that particular legislation is developing and authorities are watching upon. For example, again, Indian example, India of late we had very, very complex issues in environmental laws. And having worked with Coca-Cola, so we had a lot of issues with the environmental compliance, because people believe that what Coke does or what any soft beverage making company does is they take water from the ground, they add chemical, they add color, they add sugar, and sell it on a very high profit and they transfer all dividends to their back country. So that if that concept is there in any particular jurisdiction, so that becomes very difficult to defend, right? Because at that point in time, you have to justify that you are not only taking from the society, you are also giving back to the society. And how you have to do it? Maybe you have to create more recharge pits, or you have to create more rainwater harvesting kind of a thing. So just an example, right? So basically, which jurisdiction you work, what are the complications, which particular law is is thrown upon you, that's something which you have to see, and that's, I think, we have to decide on a case-to-case basis where we stand. I hope it's answered, right, your question, or still?
I used to work, as I told you, that was the multinational, so that the trend is to split between the general counsel position, chief compliance officer, and the anti-money laundering officer.
And all of them were reporting it to whom?
Independent line, the general counsel reporting to the CEO, compliance officer reporting to the board, especially the audit committee, and the anti-money laundering reporting to the CEO as well.
That depends how your CEO wants actually, or board of directors. But technically, if I had been on that position, I would have preferred everything reporting under the GC, because GC is a lawyer, right? He can handle and understand each and everything very at a macro level, very with a very clear thing, right?
But in some jurisdiction, they require an independence to the chief compliance officer by the law. That's why he's reporting to the audit committee.
Yeah, then we can't. Yeah, then those are part of requirement, right?
Exactly.
Yeah.
Any more?
Do we have any more questions?
Or comments are welcome from your jurisdiction. Yes, the lady.
Yeah, no, also thanks for engaging this discussion. I think that this is a kind of practice that we don't get as general counsels. We don't get to discuss about too often, about structuring the legal team. 2 years ago, the legal team was composed of legal and compliance team. But I think this is an important point to locate what is the position of the legal counsel and the in-house attorney. in the reflection whether to join it or not with the compliance function. So what we did was, the legal team was composed of very business partner people, like really aggressive attorney, but because the compliance function was embedded in the legal team, we were attracting a lot of conflict because we were also carrying out investigations that sometimes involved our colleagues and our internal clients. So that automatically placed us in a position where it was impossible to keep the reputation as being a business partner. So we made a difficult decision. We split the legal and compliance function. So now the compliance has its own personality as the regulatory function, the supervisory function, where the legal now can have the magnificent freedom to really be there for clients on a commercial standpoint and really break barriers and use the law to liberate the economic initiative. So just to give you my contribution, that's something we did in Europe, in France, and things are really much better now. I think it's a trend that is more and more used, and I think I can only encourage that, because in my own experience it really brought more business opportunities, less conflict, and also compliance function is now well defined and everyone is his own place. So that's great. So I can only encourage that. Yeah. Thanks.
So thank you so much, moderator and panelists. Now I would request our moderator and panelists to accept the memento on behalf of World Litigation Forum. Rather, I will request Andrew Hart to hand over the memento to our eminent panelist. So I would request Sabina Noreen Malik to please come over and accept the memento on behalf of WLF. Photograph.
The second one.
Yeah. Now I would request Farhat Ali Khan to please come over and accept the memento.
Upside down.
Thank you.
Now I would request Harish Kesom to please come over and accept the memento.
Thank you.
Now I would request Andrew Hart to please accept the memento on behalf of World Litigation Forum. Thank you for joining.
Thank you.
May I have a huge round of applause for the session? It was a really interesting one. And Andrew certainly made it really interesting. And of course, our panelists as well. Thank you so much, panelist and moderator. Though we will be moving to our session 5, but before that, we will be taking a short networking break for a quick coffee or tea or whatsoever beverages you like. So we will be taking a short 15 minutes break, and we'll meet again at 4 p.m. for the session 5. Thank you so much, everyone. Thank you.
me do it.
Hello, everyone. Oh, very good afternoon. Welcome back from networking lunch, networking coffee break. I understand there was a little lunch laziness in the room, and I'm sure the coffee must have kicked in some energy in all of you. So with this, I will be starting with the session 5, which is the roundtable, which speaks about the enforcement issues that arise in commercial litigation and arbitration. For this, we have some amazing panelists and moderator here. The moderator is William Leung, who is a principal solicitor advocate from William K.W. Leung and Company, Hong Kong. And then we have some amazing panelists here with us. We have Ankush K. Mehta, who is a partner at Cyril Amachand Mangaldas from India. We have Renata Berzanskini, who is a general counsel at Orlen, Lithuania. We have Antonin Sobek, who is a counsel from Dubai Arbitration Center, Dubai. We have Asim Ahmed, who is a partner at BSA Ahmed, Dubai. Then we have Matthew Page, who is a partner at Hadef and Partners, United Arab Emirates. We have Peter Smith, legal director, Charles Russell, Speechless, Dubai. We have Amirin Gogi Barides, I'm so sorry for the pronunciation, who is a partner and advocate from all over from London. So with this, I would like to welcome our moderator and panelist, and from here, I would hand it over to our moderator, William, to take it forward.
It's a very privilege to be here, to be among all of you. The topic covered two big areas, the enforcement of court judgment and the enforcement of arbitral award. Well, obviously, the enforcement of the arbitral award is under the New York Convention regime. And of course, for the court judgment, they are of different regimes. And I would let the panelists to let us know more about the difficult issues in this afternoon. Let me start with the arbitration award first. And I have got Mr. Asim Ahmed, right, of BSA Ahmed and Dubai. And he is going to cover the enforcement of foreign arbitral award through the Dubai court. And let us hear what he's going to enlighten us. Thank you.
Thank you very much. Thank you for everyone. Thank you for attendees. And it's my pleasure to be one of the panelists in this panel. And we are taking a very important issue, which is arising out enforcement in general. As we all aware that the goal of going for any litigation or arbitration or any legal procedures, the goal of that is how to get the enforcement of this judgment or award or whatever, to take back the situation if it is money or assets or any situation. This enforcement it's not open. We will talk all together for this enforcement, and I will try to focus on enforcement of foreign judgment and foreign arbitration award in UAE.
which is, I think, also it has been went through different amendment. As we all aware, for the last 4 to 5 years, Dubai, to meet its vision, try to make all the laws amended to meet the requirement of fair and justice everywhere. And one of the issue is how to execute the judgment. Before, we have a lot of judgment, but the enforcement of this judgment facing a lot of issue because of the tactic delay and the not upgraded laws in UAE to meet the requirement, and accordingly wasting of time of this during the court to enforce any judgment. In the last 4 to 5 years, UAE law has been amended so as to meet the requirement and to try to make a fast track for the enforcement of judgment. One of the issue is to enforce foreign or arbitration award issued out UAE. Before, it's long procedures to go through this channel, so as you have to come and ratify this judgment before the normal court. But according to the amendment has been done recently by and there is last amendment coming on our law number 42, 2022, which is give the full power for executing such judgment issued abroad to the execution judge. Judgment, arbitration award, provisions, orders, whatever with the 13 requirement. All this has been now given to the execution judge directly, instead of to be given before to the normal court to file a case for ratification of this award with normal hearings and many steps. Now it's become directly to the judge who need to decide within, for this either to apply or to order for enforcement or not within 5 working days, directly without notifying the other party. He will pass an order that he is ready or he is allowing enforcement of this in the court or in UAE. The other party, of course, he has a right to object against this in normal procedures. This enforcement, the execution judge has the full right to verify the required documents or the requirement of this judgment. Yani, there's 13 conditions. It's like 5 conditions the law put for the execution judge to go through it to make sure it's met, and then he will pass his order to execute this in UAE. One of these important that UAE courts are not have any jurisdiction to look the matter in which the judgment has been issued. And if UAE has a jurisdiction, he will not allow a foreign judgment to be enforced here in UAE. And also another requirement regarding the documents itself, it should be issued from the proper court and notarized properly, and the other party has been notified properly, and he has been also represented properly. In addition to general requirement, which is this judgment should not contradicted with the public orders and policy in UAE. In general, this is the requirements that need to be covered then the judge has the right, after verifying all this, just pass an order for starting the executing of this judgment. The same apply for the arbitration award. Before also we are facing a lot of issues of enforcing the arbitration award, which is issued outside UAE, how to enforce here, where to go, what to do. It's many topic, many issues has been arises here. Some of these people before go directly to the DIFC court so as to ratify this award, and then according to the protocol has been signed between DIFC and Dubai courts, that after ratifying the foreign judgment or arbitration award, then you can take it by this protocol to Dubai courts to open execution file. Still this protocol is valid, and parties can choose this way for enforcement of foreign judgment, or can go directly to the execution judge to take this enforcement order and then to proceed in the procedures. As we said before, according to the amendment has been done properly in UAE, even the judge has been given powers to ensure the executing of the judgment amongst UAE by giving him an option and powers to directly order travel ban or arrest warrant or attachment against these assets to try this not to be avoided, the execution not to be avoided, or the other party take it away. This is generally, we can say, the enforcement of foreign judgment, arbitration award, provision, order, and documented and minutes settlement. Whenever it's executable there, according to their law, it will be accepted here. Finally, I can say that this, whatever is mentioned in this law, it should not also stop or whatever requirement for the other treaties or agreements between the countries. And if another requirement need in the treaties or in the agreement, and it's needed, again, the judge he will ask for not only this requirement.
Thank you so much, Azim, for your very kind introduction of taking us through to the UAE regulations. And the next one is concerning about the arbitration award is Mr. Matthew Page. He talked about the enforcement issues regarding the DIFC, the Dubai International Financial Center, and the ADGM, Abu Dhabi Global Market Seated Arbitration Award. And let us listen to how he enlightened us about the enforcement of this seated award.
Thank you, William. As William said, I'm focusing on the question of enforcement of awards where the seat of the arbitration is the Dubai International Financial Center, the DIFC, or the Abu Dhabi Global Market, the ADGM. Now, if you're in an arbitration and you win the arbitration, one of your main concerns is to try to get the monies. So the question is, if you are the winning party in an arbitration and the other opponent fails to make payment voluntarily, what steps can you take to try to get the monies? Well, you can, of course, try to use some commercial or non-legal pressure, or you can also try to use the state's national court to try and get access to the assets. So the starting point with enforcement is that you have to think, well, where do you want to enforce your award? Where are the assets located? Because there's no point in incurring the additional cost in taking steps to enforce an award if it will not provide you with a pathway to access your opponent's assets. So where you have a DIFC seated arbitration award, the key law applying is the DIFC Arbitration Law number 1 of 2008, and that governs the arbitration procedure for enforcement. And that provides that an arbitration award shall be recognized as binding within the DIFC and shall be enforced subject to certain provisions of that law. And in the ADGM regulations 2015 apply. And that provides that an award within the meaning of that regulation shall be recognized as binding within the Abu Dhabi global market and shall be enforced within the Abu Dhabi global market as if it were a judgment of the court. So what is classified as an award within the meaning of the regulations? Well, firstly, it refers to awards made in arbitrations where the seat of arbitration is in the ADGM. Secondly, New York Convention awards. The New York Convention, of course, requires courts of contracting states to recognize and enforce awards made in other contracting states. And currently there are around 170 parties to the New York Convention. And thirdly, all other arbitral awards which are sought to be recognized and enforced in the Abu Dhabi global market, irrespective of the state or jurisdiction in which they're made. Now, as regards the procedure for enforcement, this is actually quite straightforward in the DIFC and the ADGM courts. You simply make an application for recognition enforcement ex parte, and you make an application with your original arbitration award or a certified copy, with the original arbitration agreement or a certified copy, and then you also include a draft order in both English and Arabic. Now, it's important to note there is a right to set aside the recognition order, and the defendant has an opportunity to apply within 14 days of service of the order. And that means, and the reason for that is because the application is made ex parte without the award debtor being heard. And so you have to wait until 14 days has elapsed before seeking to enforce your arbitration award. If you do make an application under either the DIFC rules or the ADGM arbitration regulations to set aside, what are the sort of grounds that can be used for challenge? Now, those particular laws set out a number of different types of grounds that you can try and use to challenge an award. That includes, for example, where the arbitration agreement is not valid, or where there was not proper notice was not given to the other party of the appointment of an arbitrator, or was otherwise that party was not able to present his case. Or if, for example, the arbitration award dealt with matters outside the scope of the submission to arbitration, or if the arbitral procedure was not in accordance with the agreement of the parties, or public policy grounds. Those are some examples of the type of grounds. And we see, for example, a party might apply to say, look, the arbitration award was not signed on every page, or was not signed on the dispositive part of the award. There's been a few cases like that recently. But those grounds for challenge are very procedural in nature, and they largely mirror the grounds in the New York Convention. Now, once you've got your recognition order and you've waited 14 days, that 14 days has elapsed, you can then apply to the DIFC court to enforce. And if there are assets in the DIFC, you can use a number of enforcement methods to try to get hold of those assets, including affixing a charge of a property, attachment of assets or earnings, execution against the assets, and the appointment of a receiver. Now, it's also useful to know that once the award has been recognized in the DIFC court or the ADGM court, the winning party can then also try to enforce it against assets held onshore in Dubai or Abu Dhabi. There is a memorandum of understanding between the ADGM and the Abu Dhabi Judicial Department providing for reciprocal enforcement of judgments and awards. And I should say also that once you get back your order from the DIFC court, it will be stamped with an executory formula, and there'll be an execution letter issued by the DIFC court. And you can then, as a judgment creditor, if you've won the case, you can take that to the onshore Dubai courts, to the execution judge, and open an execution file. then once that execution file has been opened, you have the same enforcement methods available for enforcement of a judgment, including travel bans, attaching bank accounts, shares, property, and vehicles. It should also be considered whether you have a ground to apply for precautionary attachment, because there's a delay in between obtaining the award and waiting for enforcement. In that time, if you're concerned that your opponent might try to dissipate the assets and put them beyond reach, you can consider applying for an attachment to try and stop that from happening, if you're able to show the relevant grounds. Now, I should say that the Abu Dhabi Global Market Court also has a unique feature called deputization. This is a deputization route, which is in addition to the traditional route for execution. It allows you to ask the ADGM court to order specific measures of enforcement to be taken by the Abu Dhabi Execution Court. But this is very rarely used in practice, and it tends to be mainly for judgment creditors that are not confident with going directly onshore, not confident with going directly to the Abu Dhabi Judicial Department. Now, I should just mention very briefly the topic of the conduit jurisdiction, which has been quite a topic of controversy in recent years. And in a number of previous judgments, the DIFC court confirmed that DIFC law does allow the DIFC courts to be used as a conduit jurisdiction for the purpose of enforcing both foreign and domestic arbitration awards, as well as foreign court judgments against judgment debtors located in onshore Dubai, even where the judgment debtor has no connection with the DIFC. So it's using it as the DIFC court as a conduit for enforcement purposes. And because of that, there was formed the Joint Judicial Committee, the JJC, which decides on conflicts of jurisdictions between the DIFC courts and the Dubai courts. So for example, if you have an arbitration award seated in the DIFC and you apply to the DIFC court for recognition enforcement, if your opponent applies to the onshore Dubai courts to challenge the award, you then have two conflicting jurisdictions, the Dubai court and the DIFC court. Now, if a party refers that to the JJC for determination, both sets of proceedings have to be stayed and suspended until the JJC has decided which one has correct jurisdiction. And that has been taken advantage of by parties who've used guerrilla tactics to delay enforcement. And that has caused a lot of uncertainty in recent years. But very recently, the DIFC court has indicated that it will look whether there is a genuine issue to be determined. And if not, it may be prepared to consider lifting a stay on the DIFC court proceedings and allow those to continue whilst waiting for the decision of the JJC. The JJC itself has also become less tolerant of cases being filed as a guerrilla tactic and being used as a delaying tactic, but nevertheless, there are still often delays. I should say that the ADGM courts cannot be used as a conduit jurisdiction. That's quite one of the key differences with the DIFC, that the ADGM court cannot be used as a conduit jurisdiction. And I'm conscious of the time, because I think I'm slightly coming up against time. So I'll just make one final point, which is that if you don't know where the assets are located, you can, of course, use various asset tracing methods, but there are also tools available in the DIFC court and onshore where you can apply to the DIFC court for an order to get one of the officers of the judgment debtor to come to court and give evidence under oath about the location of the assets, the nature of the assets, and also to disclose documents. And that's a tool that can be used to good effect. But overall, the key thing is to look where the assets are located and to go to the place where the relevant assets are located for the purpose of enforcement. With that, I'll hand over to William to continue. Thank you.
Thank you very much for the very enlightening contents you have shared with us. The next speaker is Renata Bersenskini. She's a general counsel of Orland, Lithuania, and she is talking about also on the arbitral award, but now on another topic of statutory limitation periods for enforcement of arbitral award before state court. And let me put...
So I want to make a distinction between recognition and enforcement and actual execution. Because recognition and enforcement of foreign arbitral awards, it's also regulated by New York Convention. Article 3 says that national rules should be applicable in recognition and enforcement. However, there is no definition in New York Convention what does it mean, recognition and enforcement. And actual execution is purely left to national laws. So after we make this distinction, when Matthew said that it's now quite popular for losing party, avoid enforcement and execution procedures and start reorganizations, and tracing assets takes long time, and in order not to lose statutory period, you need to know these statutory periods because they vary from country to country. And when I did this research, I found that, for example, in US, it's only 1 year statutory period in order to enforce foreign arbitral award. In China, it's only 2 years. But for example, in Austria, 30 years. And there are many jurisdictions which are silent on these items. As I understand, UAE also is silent, and there is no statutory period in order to enforce foreign arbitral award, and is left to national courts. The same is in Lithuania. And then is question, would still you cannot enforce it forever, so then it's question, what should you apply? So I see two alternatives: whether you apply shorter period if it's beneficial to you for the execution, at least in Lithuania it's 5 years, or you apply general period for submission of the claim, which is longer, so it's 10 years. So depending on in which party you are representing, so then at least you can apply this analogy. Another issue is in some jurisdictions, as for example also in Lithuania, there is only applied statutory period when the opponent asks. It's not automatically. So that means if it's two defendants and they lost the case and one of them asks to apply statutory period, another no, so only, and statutory period is missed, so only for this which asks can be applicable. And another tricky issue is that in some jurisdictions it's a civil law issue, regulated in civil codes, also in Lithuania, and in some jurisdictions is civil procedure. So it's also important to know. And another tricky question was from which period this statutory limitation period starts to count. So whether it's from the next day of rendering of award, or when this award is delivered to the party, or when this period of ending of voluntary execution. So I think these are the main problematic items I found. And of course, myself, I think that these recognition and enforcement procedures need to be started as soon as possible in order not to lose this period. Thanks.
Thank you, Renata, for your very enlightening speech, and we have got another speaker on the arbitration as well. Is there's Anton, right? And are you Anton? Antonian, right? Yeah, Antonian. Upon finishing the arbitral award issues, then we will go to the enforcement of judgment issues. Anton is from the Dubai Arbitration Center, DIAC. His topic is on enforceability of award from the institutional perspective, how the DIAC ensures that these awards are enforceable and what it can do to improve this enforceability. In particular, the practice of the DIAC Arbitration Court and the changes introduced following the entry into force the Decree 34 of the 2021. Antonio, yes, and Anthony, yes, the floor is yours.
Thank you very much, William, for the kind introduction. So, as you said, today I will basically discuss this issue of enforceability of arbitration awards from the institutional perspective. So, I will focus on how our arbitration center ensures that all the awards that are issued under our DIAC arbitration rules are enforceable. So maybe let me start by emphasizing that under our DIAC arbitration rules, not only the tribunal and the parties, but also the center has a duty to ensure that any award issued is enforceable at law. So this is Article 17.4 of our rules. Now, the parties usually seek enforcement of the awards at the seat of the arbitration. So we will, of course, pay attention to the law of the seat, or lex arbitrae. So as it was mentioned by one of the panelists, basically if the arbitration is seated in onshore Dubai, we will consider the UAE federal arbitration law from 2018. If the arbitration is seated in DIFC, then we will consider, of course, the DIFC arbitration law from 2008. Now, some of the parties, of course, will seek enforcement of the awards in other countries, and those countries are usually signatories to the New York Convention. So, of course, we will also ensure that any award issued under the DIAC arbitration rules are also compliant with the New York Convention, and in particular Article 5. Now, that being said, at any stage of the proceedings, we will make sure that, once the award is issued, it is enforceable. So let me give you some example. Prior to the registration of the request for arbitration, we will, of course, verify that the parties agreed to arbitrate their dispute under our DIAC arbitration rules. So, for instance, if the parties just agreed to arbitrate in Dubai, this is insufficient to establish the jurisdiction of our center, and usually the arbitration court will conclude that we have no jurisdiction. Now, after the registration of the request for arbitration and prior to the constitution of the tribunal, we will verify, or we will ensure that the tribunal is selected and appointed in accordance with the arbitration agreement and the DIAC arbitration rules. After the constitution of the tribunal, we will also check or verify that due process is respected and that each party has been given an opportunity to present its case. And of course, at the end of the proceedings, we will perform soft scrutiny of the tribunal's awards to ensure that they are enforceable and that there are no potential grounds for setting aside. Now, I have mentioned this soft scrutiny of the final awards, and this is something completely new. So, following the entry into force of Decree 34 of 2021, the statute of our center has been amended, and now this soft scrutiny is mandatory. So Article 11.8 of our statute now provides that the arbitration court supervises the review of the tribunal's awards in terms of form in order to ensure their validity and enforceability. So in practice, we will ask each tribunal to submit its final award to the center for mandatory scrutiny at least 15 days prior to the expiry of the current time limit for issuing the final award. Now, different situations may arise. Of course, if the tribunal submits its final award, we have no comments, then there is no issue. The tribunal can proceed to issue it. If we provide comments and the tribunal implements those comments, again, there is no issue. The tribunal can proceed to issue its final award. Now, the situation is slightly more complicated if the tribunal decides to skip this mandatory step and doesn't wait for the soft scrutiny by the center and issues the final award. Now, in this situation, usually the arbitration court decides to issue a warning to the tribunal, but if the award doesn't satisfy the center's quality requirements, then it can decide to completely remove the arbitrator from the list of arbitrators. And the final situation is when basically the tribunal submits its award to the center. We provide comments, but the tribunal is either unwilling or unable to implement those suggestions. So in this situation, which is of course quite delicate, the arbitration court can decide, depending of course on the seriousness of the required changes, to revoke the appointment of that arbitrator. And in doing so, it can rely on Article 16.2, which provides that the appointment of the arbitrator can be revoked by the arbitration court on its own initiative if the arbitrator acts or has acted in violation of the agreement to arbitrate or the rules. And as an illustration, recently the arbitration court decided to revoke the appointment of an arbitrator who failed to provide reasons for its decisions in its award and whose English was difficult to understand. So the arbitrator was unable basically to implement the required changes to the award, and therefore his appointment was revoked. And so I'm mindful of the time, so perhaps let me move to the last part of my presentation and just very briefly discuss what can be done by our center to further improve this future enforceability of our awards. So I will only focus on two initiatives which have been recently discussed internally by our center. So the first one is to build closer ties with local courts, including the Dubai courts and DIFC courts, in order to enhance transparency and predictability in terms of the enforcement of the awards. So for the time being, our center has very little visibility as to what happens with our DIAC awards once they are issued. So it would be helpful, of course, if the local courts could provide us with the relevant statistics. For instance, how many awards are enforced? How many awards are set aside? What are the reasons for the non-enforcement, and so on? So we could use this data to basically cure any reasons for non-enforcement in future cases. And we could also share this data with the parties so that they have more confidence in settling their disputes through DIAC arbitration seated locally. And I mean, this kind of proposal has already been implemented by some of the centers. So for instance, I understand that the Saudi Center for Commercial Arbitration cooperates with the Saudi courts in order to facilitate this information sharing. And the second initiative that we have been discussing is to put in place specific training for arbitrators, especially first-time appointees or arbitrators from outside the region who don't have necessarily experience with the local laws and with the DIAC arbitration rules and processes. And so we could imagine that arbitrators who have completed this specific training would be more likely to be selected for appointment by the arbitration court, because this training would give the arbitration court additional guarantee that those arbitrators are able to issue enforceable awards. And again, this kind of training has already been put in place by some institutions, including the ICC, which now offers in-person and virtual training for arbitrators. So I will stop here. Thank you very much.
Oh yes, very good time management. You're just on time. Thank you very much, and Tony. Now, our next panelist is Mr. Peter Smith. Peter is the now we are on the court judgment enforcement now. Peter is the legal director of the international law firm Charles Russell Speechley, LLP, and his topic is on three topics. One is the Abu Dhabi global market and the DIFC enforcement with a UK as link. And the second topic is growing findings of reciprocity between the UK and the UAE. And then the third issue is the future of the UAE cross-border insolvency in light of the Salem, Mohammed, Bolama, Atimani, and others. This case, the name of the case. I let Peter to take us through all these three difficult issues. Thank you, Peter.
Thank you, William. The enforceability of foreign judgments in the UAE courts is governed by Article 85 of the Cabinet Decision 57 of 2018 that provides that foreign judgments can be executed in the UAE under the same conditions as prescribed in the law of the foreign country for the execution and judgments of orders and judgments issued in the UAE. So there's the principle of reciprocity. I think a major update on the UAE's jurisprudence over the last year vis-à-vis the United Kingdom. So the UAE is bound into several conventions for the enforcement of foreign judgments, like the GCC Convention and the Riyadh Convention. But with states outside of the Arab world, things are more complicated. There are very few bilateral treaties with those foreign states that allow for enforcement. And so, as it were, the UAE's common law rules apply, and I say that generally speaking, knowing it's a civil code state. The principal requirement is set out there in Article 85 that there needs to be a degree of reciprocity between the states. Towards the tail end of 2020, the English High Court recognised and enforced a Dubai court judgment in the case of Lencor Energy Trading DMCC and Puri. Now, a number of issues were raised there. Effectively, that was a bounce check case that Lencor had sued Mr. Puri on successfully in the Dubai courts, and they were seeking to enforce against his assets in the United Kingdom, or in England more specifically. The English court enforced the Dubai court judgment, notwithstanding arguments that it would be contrary to public policy on various grounds, including the underlying contract was tainted by illegality. However, the English court made clear that public policy arguments before that court were not accepted, because it's not about the public policy of the process by which the judgment's rendered. It's the public policy of the judgment itself, it says. It is the judgment and not the underlying transaction upon which the judgment is based, which must offend English public policy. So the judgment was deemed by the English court to be satisfactory, and so it was enforced. It didn't matter that the facts pattern on which the foreign judgment was based might generate a different outcome had the same facts been tried before the English courts. In other words, the English court was happy to say, we don't let people sue on bounce checks in England under English law, not in the same way as it happens in the UAE, but nonetheless we're going to respect the UAE claim and the UAE court's actions. The judgment of the Dubai court since its original form was enforceable in England, and as a result, in 2022, the UAE Ministry of Justice issued a communique in the summer, I think it was July or August last year, confirming that judgments issued by the English courts should now be enforced in the UAE under that principle of reciprocity enshrined in Article 85. Now, this doesn't mean that the UAE courts will automatically enforce all English court judgments. Article 85.2 of the Cabinet Decision also requires the UAE courts to look at whether things like the UAE courts would have had exclusive jurisdiction over the claim that has been sued in the foreign jurisdiction. So, for example, it involves a Dubai government entity, which must be, I think, litigated before the Dubai courts, or things like a commercial agencies agreement as well, which I think is a mandatory claim to bring in the Dubai courts. So they will restrain what foreign courts do when they're trying to enforce in the UAE. They'll also consider where the judgment is to be enforced conflicts with the judgment of the UAE courts. And Matthew raised the problem of the Joint Judicial Tribunal set up in 2016 and its ability to stymie proceedings before either the DIFC courts or the Dubai courts, depending which one's the victim in any particular JJC application. And finally, the UAE courts will consider whether the judgment is consistent with public policy in the UAE. The only times I've had public policy in a sort of genuine commercial dispute, so not one about gambling or anything that might be considered unenforceable in the UAE, has been to do with contingency of fee agreements and damages-based agreements and forms of funding for the lawyers in the disputes, both arbitration and judgments. And something to be aware of for foreign lawyers is that they need to make sure that if they want to try and recover their costs in an award which they then want to enforce in the UAE, that the way in which they're entitled to that costs is lawful under UAE law. It's worth noting that there's nothing in the Cabinet decision that expressly prohibits a UAE court from reviewing the merits of an English court judgment, even if the criteria in Article 85 are otherwise satisfied. But the general belief of the few cases I've seen that people have tried to enforce in the UAE courts from England and elsewhere, like I said, outside of the Riyadh and GCC conventions, is that the courts do not engage in that much scrutiny. Now, there was a second case in England, this right at the tail end of 2022, involving a security for costs application. So in England, a debtor can say, the defendant in litigation can say to the court, please oblige the claimant to post security in case the defendant is successful and needs to recover his or her legal costs from the claimant. In Invest Bank and Al Husseini and others, Mr. Justice Bryan dismissed applications for security for costs by 4 defendants against the claimant, which is a bank based here in the UAE. The defendants contended that security should be ordered in circumstances where there was a real risk that an English costs order would not be enforceable in the UAE, either onshore or offshore in the DIFC. Now, the judge dismissed the application after hearing quite a lot of UAE law expert evidence of dubious quality. But the judge rejected the extensive expert evidence on UAE law submitted by the defendants to the effect that there was a real risk enforcement could be refused because of an absence of reciprocity of enforcement between the UAE and England, or because the costs order would be contrary to the public policy of the UAE. So in rejecting the evidence, the judge held that it's clear that there is reciprocity of enforcement of judgments between the two systems, and that enforcement of a costs order is not contrary to the public policy of the UAE in and of itself. The judge found that a straightforward route to the enforcement would also be to use the conduit jurisdiction of the DIFC. So in other countries recognise the inherent ability of the UAE court system. They apply their own concepts. So like I said, that's an English judge thinking about English costs orders and how different litigation is in many common law jurisdictions. No need to prove a power of attorney. Doctrines of ostensible authority and implied authority that just don't exist in many civil law jurisdictions. It's much easier to litigate, and there's maybe more flexibility in the sorts of cost orders that can be made. But my hope would be that in 2023, 2024, some of those orders actually come to the UAE for enforcement, and we start seeing Court of Appeal or Court of Cassation judgments that recognise them and provide a degree of precedent. As William said, there was one more case that I was going to briefly mention, which is one called Al-Tamimi, but I'm not sure it has anything to do with the law firm. If you give me a second, I'll put my notes on that. Al-Tamimi. So Al-Tamimi is, Mr. Al-Tamimi is actually the trustee of properties relating to, I think, the collapse of NMC, and it's one of the guarantors. So under the UAE, I'm going to get this right, personal bankruptcy law, rather than insolvency. Under the bankruptcy law, a trustee can be appointed over a person's assets when he or she is unable to meet the debts against them. And so in this case, one of the guarantors for some of the NMC group entities had big guarantees claimed or called upon by the banks that had lent money to these groups and was unable to pay them. So the Abu Dhabi courts, not the ADGM, but the Abu Dhabi Justice Department courts, or the Emirate of Abu Dhabi, appointed a trustee on behalf of, I think, some of the creditors, but not all of the creditors, against this guarantor. And in fact, it wasn't the complete suite of guarantors in relation to these secured assets either, but only some of them. Now, then, the trustee tried to obtain a stay from the DIFC courts where the banks were suing for the actual debt, I think, of the underlying loan documents that had been called on. So the question was whether or not the Abu Dhabi insolvency proceeding or bankruptcy proceeding could be recognised in the DIFC courts and cause a stay in the action in the DIFC. And this is it sounds a bit remote. I mean, cross-border insolvency is not that easy to begin with, but I think this case in the DIFC, it just shows that there are gaps in the UAE's insolvency regime. The DIFC court considered the stay application and rejected it in the end. There are a number, I think there are about 7 points that considered. Number one was the insolvency proceeding to be commenced by only one of the many parties, who was one of the personal guarantors, who were involved in the DIFC proceedings. So there wasn't an exact overlap between the Abu Dhabi onshore and the DIFC proceedings. Number two, the DIFC law relating to insolvency only covers corporations because it uses the word, the idea is that corporations are insolvent and individuals are bankrupt, isn't it? There's a mix-up in taxonomy between the onshore and the offshore laws. Number three, the defendants. All right, okay, well, I'm not going to go through the rest of the points, but it just simply serves to show that at the end of the day, the DIFC courts were not willing to just accept as read the Abu Dhabi proceedings, and this has consequences for the recognition and enforcement of any orders in those insolvency proceedings.
Thank you so much, Peter, for the in-depth analysis of the interactions of the UAE and the UK judgments. The next panelist is Mr. Ashok Mehta of Serial Amateuran and Bangladesh, which is the largest one of the largest firm in India. And Mr. Ashok,
thank you.
Please, you are letting us know the Indian perspective. The floor is yours.
Thank you, panelists. I'm just going to divide this brief talk in 3 parts. One, what is the law behind the execution proceedings? So what does the court look at? Because I'm been asked to speak on the foreign judgment and the foreign award. The foreign judgment enforcement is recognized under the CPC, or the Code of Civil Procedure, and the foreign award is under the Arbitration Act. The CPC, some of the relevant sections are Section 2, which talks about a foreign decree or a foreign judgment, Section 44A, and I'll come to that in a minute, and Section 13. And under the Arbitration Act, we have Part 2, which deals with foreign award recognition under the New York and the Geneva Conventions. Now, India and UAE on exactly this day 3 years ago signed a reciprocating arrangement, which meant that all decrees passed by a superior court in the UAE is recognized in India. Now, that makes it very, very significant because, of course, it inspires everyone, including the business community, commercial relations, so on and so forth, that it really, when a judgment is passed by a court of a reciprocating territory in India, it doesn't have to go through the entire rigmarole and process or being tried as a separate process. So that's point number one. I'm going to be talking about 2 other things. One, practice notes or practical considerations when it comes to basically going ahead with an enforcement, either in the form of an execution or in the form of an enforcement of an award. And third, certain case studies that may help you gain some insight. Typically, when you get an award, either or a decree, whether it's in the reciprocating territory or not, it goes, where does this decree go? Where do you take it? India is a large country, right? I mean, do you take it to Mumbai? Do you take it to Delhi? No. You'll take it to the court which has jurisdiction over the judgment debtor's assets or the judgment debtor. So great, you'll take it there, but then what happens? What if the judgment debtor doesn't have assets there, right? So before that, and when the sort of the paperwork comes to us, prior to us, assessing about whether this particular case will need to be filed in XYZ court, we will have to understand, and through various legal searches and means, find and understand whether the judgment debtor in fact has assets. in whose assets, sometimes we have the assets being transferred in favor of trust companies, family members, so on and so forth, right? This is quite common. So starting point would be to assess where the assets are located, to maybe consider once in the enforcement process itself, you take out a disclosure affidavit. Basically, you make the judgment debtor compel on oath as to where his assets are and in whose names. In certain cases and certain matters, assets which are transferred within a period of 1 year past the passing of the order can also come up under scrutiny. So these things become very, very important. And of course, we have asset tracing experts to even find out, where, the assets may be. So that's point number 2. Point number 3 is certain cases. So we were in fact entrusted with doing a matter under the, where a judgment was part in the DIFC court, where we had received a freezing order. And from an Indian court's perspective, we were asked to check if the freezing order was complied with all the prescriptions under the DIFC law. So one was, which I understand, of course, subject to correction, is that the order was delivered and the judgment debtor was made to know that he has been aware of the contents of the order. So that's one of the criteria that we've had to face when we were in India. And of course, once the matter was sort of transferred into India and the execution proceedings were underway, the execution court will look at, as I was coming back to section 13 of the CPC, which sees that whether the party was under any incapacity, whether there were any issues of natural justice, whether there was an issue of the bias of the tribunal, so on and so forth, which come into play as far as the enforcement issue is concerned. A couple of other cases. One, we had the occasion to deal with an award passed by the SIAC. That's the Singapore International Arbitration Center. In that case was quite unique because again it was a judgment debtor. There was a default judgment, so to speak. There was no opposition to the amount that was in question as well. So we used that award to basically go under the IBC proceedings, which is the insolvency process. And we took that as an undisputed claim by the judgment debtor and eventually got parties to settle. One concluding point that I can say is that at times, as a preemptive measure, what we do is, why are we faced with issues which sort of get concluded, let's say when we are looking at execution, and why can't any, if I may use the term, blue sky thinking happen in India? That's because most of the paperwork, the contracts are all executed outside of India. One can consider at the time of formation of these documents or arrangements, if there is a likelihood of the borrower, client, customer, whoever they may be, the counterparty, if there is one leg in India, it may always be open to have some sort of a correspondence or a channel open in India, should you want to open a communication in India separately. Thank you.
Thank you so much, Andrew. We have got the last but not least panelist, Mr. Amaran Gopariji. He is the partner of the law firm MGAP in London. His topic is on cross-jurisdictional enforcement of state court monetary judgments, practical issues. Amaran, yes.
Yes, thank you very much.
Thank you so much.
I'm the last one. Just I won't take you long, because my best audience is tired lawyers. So I want to talk about awards, principally because we don't do awards. Enforcement of awards. I'm head of debt recovery and asset tracing practice of a boutique law firm based in Cyprus, London, and Tbilisi, Georgia. So we work for 15 years for the banks in Russia, Ukraine, Georgia, Armenia, and Kazakhstan. So the major target actually is to chase debtors. The template of the debtor is, ideal template of the debtor is kind of, there are two types actually. The guy who fled away with money, or with personal guarantees given, or actually the owner of the bank, of the collapsed bank. So then we work for the authority of the country which hires us to enforce the judgment. So how to say in 1 minute the experience of 15 years. We had dozens of enforcements. I should stress out the enforcement of state courts, not awards. Awards is quite a regulated area, understandable, and state courts enforcement is the area where practice never meets theory. Every jurisdiction is different and absolutely unpredictable during the enforcement. So the key point actually, from my experience, from the experience of 15 years of enforcement of state monetary judgment is never start estimating the case with is there reciprocity or no, there is no reciprocity. Start with asset approach. So firstly, when you start the enforcement or just you have the judgment to be enforced, you should hire complex project managers, a massive detective approach to detect the assets worldwide or Europe-wide. And just my precaution to you, never hire the big firms for that, because it's absolutely useless, and just the result will never provide you with the true understanding where the assets are. So when you do understand where the assets are, the usual mistake of the bank's stressed asset department head of it is he goes to some kind of reputable jurisdiction somewhere in England or Switzerland for disclosure, and in spending $10-15 million in 2 years, he understands where the assets are, and when he goes for enforcement, there is no assets there at all. So I would say this is the key point for state and monetary judgment enforcement, is to have the full picture of the assets location and go to the jurisdiction where they are, not depending is there reciprocity or there is no reciprocity there. So actually the three opportunities for enforcement are just the usual exequator, when there is a reciprocity and there is an agreement between the country. If there is no such reciprocity, you go via new proceeding there, but still chasing the injunction of the assets. And the third one, and the last one, just the most beautiful one, trendy one, is the cross-border bankruptcy and insolvency. So you can go, and there is a quite new trend in judicial systems of some countries in Europe and, for example, in Israel, where even if you cannot attach the assets or somehow affect the assets via the exequator or other new proceeding, you can launch the insolvency proceeding in the country where the initial judgment was issued, and then after that just legalize and they recognize the authority of the foreign court-appointed trustee. Just I could say proudly, just 2 weeks ago we made the first precedent in Israel, where the first instance court recognized the authority of the Russian trustee. It's quite an outstanding thing to happen, and all the assets were arrested within that bankruptcy authorization. That's what I wanted to say.
Okay, yes. I think upon hearing all the talented panelists, I wonder if there are any questions to be raised in the floor or within the panelists. Yes.
Anthony, what happened to the arbitrator you had to remove and strike off Diane's list? What happened to the arbitral award?
Thank you for this question. So basically, the award is issued by the tribunal, and this is basically the punishment of the tribunal. So nothing will happen with the award, and the parties will not even know that this arbitrator was removed from the list of arbitrators. This is just an internal measure that the arbitration court will take to prevent, any other incidents in the future. And just to clarify, this is also a recent change. Basically now, in order for the arbitration court to appoint an arbitrator, this person has to be on our list of arbitrators. In the past, the arbitration court could select and appoint any individual. Now, the condition is that this person is on our list. So if the arbitration court takes the decision to remove this person, we will no longer be able to appoint him unless, of course, this person was selected by the parties.
I have a clarifying question. That means under your rules, the scrutiny is not obligatory proceeding as in ICC rules. I am also a court member of ICC in Paris, and it's obligatory to have scrutiny. That means it is impossible for the arbitrators not to give a award for the scrutiny. That means it's voluntary.
So actually, it used to be voluntary, but now this is a mandatory step. And so if the tribunal doesn't comply, we cannot do anything. The tribunal basically proceeds to issue the award, and once the award is issued, it's too late to do something. So again, as a punishment, the arbitration court may decide to remove this arbitrator from the list, but we cannot do anything more than this. But yes, just to clarify, now soft scrutiny is mandatory. But probably, as you mentioned, ICC performs this soft scrutiny quite in detail. Our soft scrutiny is more soft, superficial, yes.
I can see there are some hands raised in the floor. Can you please?
Can you give that one? We'll change the battery for this.
Well, I mean, I just... DIFC seated, and they tried to enforce the
Thank you. So thank you everyone. So my question to you, sir, about the enforcement in India, because we have a practical case where we have to file a case against an Indian company, but they don't have any residence in UAE. So we were contemplating about one of two options, either to file a case with an Indian law firm in India and to have enforcement against them there, or the second option, as long as there is reciprocity principle now between India and UAE, that we can file a case here in UAE with a UAE law firm, have a judgment, then have a final judgment after that. If no appeal is done, then we take this judgment to India for enforcement. So my question here, can this second option be doable, that we file a case here, have everything done in UAE, then once we have a final judgment, we go to India with any Indian law firm just for the execution process. So can this be doable? This is the question. Thank you so much.
Is it good now? Oh. Here?
This mic. The round.
This is here? Okay, is it good? Okay, thanks. So listen, it depends on what are you seeking. right? Are you seeking a ultimate judgment? Are you seeking some interim reliefs? Because if you are seeking interim reliefs from somebody disposing of their assets or running away or whatever it is, that interim order in a UAE court will not be recognized in India. What has to be recognized in India is a final judgment. So that's very important. Time is of the essence, right? So it depends on, you know, the nature of the issue. If you're filing a money claim in India, okay, there is a Commercial Courts Act right now, which effectively modifies the CPC or the Code of Civil Procedure, which mandates at least that you have to complete a matter within 3 years, which is not too bad, right? And if you can seek interim reliefs prior to then, that may be a good idea to just directly come into India.
So it is not an interim or injunctional relief that we are seeking. No, we are seeking, it is a final judgment and we want to enforce in India.
So you have crossed this, you've got a final judgment, is that what you're saying? Or you
Yes, so what I'm saying simply, if I have a final judgment for your UAE law firm for 100,000 dirham, let's say, then we want to go to India to enforce it.
Yes.
Is it doable?
Yes, of course.
Oh, this is the question.
Okay,
yeah.
okay,
Yeah.
fine, yeah.
Thank you so much. Thank you.
Thank you very much, everybody. My question, as it pertains to the enforceability of an arbitration award, my question, I suppose, is to nobody directly, but to a variety of everybody on the panel, because everybody has such a wide global experience. To what extent is the behavior and the conduct of the parties throughout the course of the arbitration and have an impact on the enforceability of an arbitral award? Abhishek, you just commented that in India the award has to be enforced within 3 years, I think you just said. And so I'm wondering if any conduct, poor behavior throughout the course of the proceedings has an impact on that. And if I may, my practice is an e-discovery practice, and so as we have in England and Wales, in litigation at the very least, a very strong encouragement for litigious parties to rely on technology in an increasing manner, and I'm wondering if anybody has an experience of that in arbitration proceedings.
I'll just go first. So first of all, just a clarification. The Limitation Act is for enforcement of a decree. So once you have a decree, then it's 3 years. When you say conduct of the parties, you mean they don't appear in the tribunal at all? Or what does the conduct mean? I mean, is there, it's a default, is an ex parte judgment or?
No, I'm thinking more about, thank you. I'm thinking more about lack of control of spend, and perhaps sort of seeking to move back to the bad old days of litigation in terms of trying to outspend the other party.
Delay tactics and other things. So, okay, so let me start. In an arbitration in India, it's time bound again. It's max 18 months, okay? And if you need further time, you need to go back to the court. So in that sense, the fees of the arbitrator is also fixed. So as such, you know, and the arbitrator somewhere, I mean, on a delicate side, has the power to push the parties or nudge the parties to a mediation as well. So in given this, I don't think the conduct will be as much. I think the arbitrators are also answerable to the parties and the court that appoints them. I'm not sure they will just let it you know, pass in that sense. So they'll be able to stick to enforce their you know, plan.
In terms of the conduct of the parties during the arbitration, if there has been some sort of particularly poor conduct by one of the parties, whether the claimant or the respondent, whether it be delaying tactics or whether it be let's say a party's been ordered to produce documents and refuses to do so, or just simply doesn't appear, all these sorts of things, it tends to be the case that the tribunal will take into account all of that sort of behavior in its award. And in particular, it tends to, in its award of costs, when it's allocating legal costs and arbitration costs, it's going to take into account all of those sorts of things. And it can make an appropriate award of costs against the party who's been performing poorly. And whether that be in the percentage of costs awarded, in terms of legal costs and arbitration costs, or that sort of measure. So I think it tends to be taken into account by the tribunal in its award. And it's in that context. Of course, if a party is in the enforcement context, if a party is performing or doing bad things to, for example, try and dissipate assets, that sort of thing, then one can look at precautionary attachments. One can look at tools that can be used to try and find and locate the assets. I think that's the context in that sort of bad, poor conduct. Yeah.
If I may add one point is, I think during the arbitration process, the suffering parties or potentially suffering party may apply to the tribunal for a preservation order in freezing the asset concerned if there are evidence of the one of the party in dissipating the asset. But I think there's a possible kind of thinking.
I can answer from my practice at Vilnius Court of Commercial Arbitration, because within 23 years I was arbitrator on more than 70 cases. So then if I see that the party really has this guerrilla tactics, at least in my experience, it reflects on the legal fees, distribution of legal fees, because arbitrator fees, they are kind of expressed in the rule that the winning party gets, but legal fees you can really adjust. And so I think it's this as regards, we don't have discovery proceedings in our jurisdiction, and restraining orders very, very rare, because we as arbitrators are like afraid of liability if we issue restraining order, and then what's then can be against you. So that is.
So I was going to say that basically this issue of guerrilla tactics should be addressed by the tribunal, of course, and to deal with, it's the role of the tribunal. But before the constitution of the tribunal, it's also the role of the institution, unless it's ad hoc arbitration. And so in the context of institutional arbitration, we will always try to balance, due process and these guerrilla tactics, because the parties will often tend to delay the proceedings, delay the constitution of the tribunal, etc. On the other hand, we will need to ensure that, for instance, the respondent was notified of the request for arbitration and was offered the opportunity to respond to the request for arbitration. So all the time we will try to balance, the interest of, due process and speedy proceedings.
So do we have more questions or any comment or anything that you would want to add in the session? We still have some time left, maybe 10 minutes more, and we can make a good use of that 10 minutes. So if you have questions from the audience, like from the panelists, bring it on. I see there are no questions. People are tired. It's already been a long day for all of us, for our panelists, for the lawyers who are in the audience. So with this, we will be wrapping up the session 5. And I would like to thank our moderator and panelists for joining us in the session. But before I wrap it up, I would request William Lewing to come forward and hand over the mentor to our eminent panelist on behalf of World Litigation Forum. So we can come down, and that would be easier. Yes. So I would request Ankush Mehta to please come forward and accept the memento. Now I would request Renata Berzanskin to come forward and accept the memento on behalf of World Litigation Forum. I would request Antonin Sobek to please come forward and accept the memento. Now, I would request Asim Ahmed to please come forward and accept the memento on behalf of World Litigation Forum. Now, I would request Matthew Page to please come forward. Now, I would request Peter Smith to please come forward and accept the memento on behalf of World Litigation Forum. Now, I would request Amiran Gogi Barids to please come forward and accept the memento on behalf of World Litigation Forum. Now, I would request William Lewing to please accept the memento on behalf of World Litigation Forum. Thank you for joining. Thank you so much, panelists and moderator. With this, we come to the end of this day one, and it has been a wonderful and amazing day for all of us. And tomorrow again at 9 a.m. we will have rest of the sessions, wherein we will be covering some of the trending topics and the challenges that are happening in the litigation industry. So thank you so much, panelists. Thank you, moderator. Thank you, attendees, and our sponsor and exhibitor for joining on the day one. I'll meet you again tomorrow at 9 a.m. Thank you so much. Have a lovely evening.